Director of Justice Access Point, partly responsible for our being here. I don't know whether Ms. Patricia is here yet. Comrade Patricia Navi, I don't know if you're here yet, or a representative to that effect. If not, then I also invite Yona to as well take a seat here for a few remarks, and then we can commence our conversation very shortly. In fact, for not wasting time, Yona, you can begin here with a few opening remarks.
O Uganda, may God uphold thee. We lay our future in thy hand. Good morning, fellow citizens. Habari zenyu nyi yote. Yona Wanjala is my name. I work for the Civic Advisory Hub. The Civic Advisory Hub is an NGO that works on transnational organized crime with a financial dimension and how the legal and normative institutional frameworks intersect with civic space. I am a Ugandan, born and raised in this country. We converge here under one of the initiatives by the Civic Advisory Hub called the Leaders Talk Africa, which is basically an initiative that promotes civic space diplomacy to debate on key policy issues, to engage with key stakeholders on issues that matter for the continent, but also for particular countries. Today, uniquely, we are here to discuss what I would call a legislative tsunami, titled the Sovereignty Protection Bill. It was like a dream when a fake bill was first dropped on social media, but it could have been a strategy to see, let us throw the stone and we see the reaction. What was a dream came into reality when we saw our brothers, sons, daughters of this nation in Chankwanzi flagging the Sovereignty Protection Bill. Of course, Cabinet had already debated on it and presented it to the powers that be. As a civic society leader in this country, I thought it would not be just to us and justice to this nation if we all kept quiet and not debate on this bill. We were lucky and happy that again, as collective demands, we united efforts with colleagues from the Justice Access Point, colleagues from FOWODE, and other civil society players to engage on this bill. We've met several stakeholders to create insights and understanding on the bill. But that was not enough. The management and the board of the Civic Advisory Hub recommended that there is need to have a legal eye. So, as Civic Advisory Hub, we contracted one of our very fine brains in this country when it comes to legislation, none other than Council Onyango. Please, you can stand up. Of Onyango and Company Advocates, to help us make an analysis, simplify clause by clause, mirror it with other legislative regimes in this country, in line with the sovereignty of the Ugandans, whose future we lay in God. So today, we are going to have a presentation by the legal team. However, our work is not unique to what other institutions have done. Justice Access Point has had also an analysis that mirrors the same. FOWODE has had analysis that mirrors the same. So how would we merge these bills, these analyses, and make a submission from here? We've also called sector leaders from across the region, Eastern, Western, Northern, and Central, to build collective power, to make collective recommendations that, if possible, can obstruct or intercept the bill from passing. Please note, the bill has a very good brand, the Sovereignty Protection Bill. Very, very good branding. Of course, there is no nation that does not want to protect its sovereignty. But I think if at all protecting sovereignty makes you stateless, when countries globally are closing their borders, ask yourself, where should one go? If the bill is to silence you to speak on anything that can connote influencing government policy, then how do you make your constructive submission or argument on similar policies? It reminds me of one of the old women, for those who did Peacock, who did European history, when he had to exclaim that I cannot speak because Metternich will hear. You remember the Metternich systems. Actually, he had almost a similar bill where he employed secretaries in post offices to open and seal letters. So I think we are here to discuss openly, constructively, and make constructive recommendations. We shall have done justice to our sons and daughters in this country. And please note, let us all mobilize our members of parliament. Let us all mobilize the religious leaders. Let us mobilize every Ugandan to say no to this bill. Because if it's planning to silence you, who does policy analysis, engagement, and constructive, maybe a worse bill again is coming after this. Ask yourself, why the bill and why now? What is likely to follow after this bill? So I don't want to take a lot of your time, but sometimes when you talk about the Sovereignty and Protection Bill, it has a ripple effect on every Ugandan. And it's unfortunate that if it is passed, our members shall have made us, members of parliament shall have made us stateless in the nation where we belong. Thank you, colleagues. Thank you, fellow Ugandans. We stand Ugandans, we remain Ugandans. Thank you.
Another hand clap for Comrade Yona. Of course, you know that this bill is coming in a global context where countries are retreating into asserting sovereignty. the threat of whether the global order can hold. All of us are seeing it with the wars going on, with the UN under discretion, with the AU under discretion. So there's an urgency worldwide for countries to retreat into sovereign power. The question of the day that internationally we are facing is, what is this retreat into sovereign power? A redefinition, a reincarnation of new sovereignty, not as known before the pre-order that we have been dealing in. So it has also that global connotation that Comrade Yona hinted on slightly. I'd like to invite Mr. Muhammad Ndifuna. Whenever I get an opportunity, I don't like giving eulogies when someone is dead, but whenever I get an opportunity, I always thank Mr. Ndifuna for the opportunities he gave us while at Urinate. Some of you have CEOs who never allow you to travel. Every thing the CEOs are ongoing. But Mr. Ndifuna really opened doors for us, and so I'm still grateful, and I'm honored to welcome you now. Yes.
Good morning, ladies and gentlemen. I'm Ndifuna Mohammed. I come from Justice Access Point. We work on civic rights and civic space. We work on countering violent extremism. We work on security sector reform. We work on human rights and rule of law. Broadly, those are the programming areas of Justice Access Point. So the subject that we are talking about is very central to the kind of work we do. And we can't say we've been taken by surprise. They say the Nigerians, but I think in many other traditions, you can tell the tree on which the bird is going to perch by the tilt of its wings. We had already the talk about formulation of the NGO funding bill. What has happened is that they have simply widened the net, because they felt probably they were getting smaller fish. They wanted a much bigger framework. So what we are seeing now, we can say we saw it coming. Having said that, we are now in a situation where we must be seized with the bill, because it is now a reality. It is going to happen. Now, what is our concern? The Constitution provides us guarantees for self-determination, for exercise of free will, and anchors our rights in Chapter 4. So, on the face of it, it would appear as if we are safe and secure. But when you look at what is coming, for example, in this bill, you can see that it is all threatened. What we have is a massive bill that is sitting or threatens to sit on the Constitution, because practically it is touching on everything. But when you look at the issue of sovereignty, and you see where the Constitution has laid emphasis, free will, self-determination, what can threaten free will? Free will can be threatened both externally and internally, isn't it? For example, if there is an election and a coup follows an election, can't you say the free will of the people has been overturned? Or there is an election and the winner is not announced? You have turned free will on its head. So, sovereignty can be threatened both internally and externally. So, it's not simply a question of thinking. When you're talking about sovereignty, you have to talk about foreigners. Having said that, I think we need to be seized with the details of the bill. So I'm happy that we have this space and moment to look into some of these provisions. they said that the title of the bill is misleading. I don't know how many of you might have heard about the satanic verses. The satanic verses. Solomon Rushdie's satanic verses. The satanic verses are in that bill. So it's our responsibility to bring them out, talk about them, and share them so that actually nobody is saying, I didn't know. I didn't know. There is, of course, determination to pass this. That should not discourage us. Let's come out and have this done. Justice Access Point has carried out 2 audits. One is the legal human rights audit, which is part of the conversation that is going to be unfolded shortly. The other is the political economy, because we know that sometimes our leaders retreat in that front when discussing these matters. It's not just about the law. But so that other audit unveils the shocks that this bill will unravel on the social, economic and political dimensions away from the law. So all that is available as information for us to engage with and be seized with this conversation. I'm happy that we have this moment. Thank you very much. James, thank you for that moment.
Thank you so much, and I'll request that you take leave, Comrade Yona and Mr. Ndifuna. And we also highlight the fact that, like Mr. Ndifuna has noted, the different facets or angles of analysis that are incarnate in this law, political economy, social political, but also we are alive to the fact that this is one of the highly securitized law, or the highly securitizing law that our country has seen since 1962 because of its capacity to actually capture and encircle you in a particular cocoon where you can't, gate out unless you prove some things. Okay, classification law, and of course the security angle, which is also the highly built argument behind this. Let me now invite the legal team that has done this analysis, of course, over and above the one of JAP and FOWODE. And ultimately, comrades, the idea is for us to be well informed about this bill and what it attains or claims, and then we can perhaps engage from an informed point of view. So I'm going to invite Comrade Onyango and the team to take the seats here, who are going to take us through this discussion. Comrades, you are highly invited. I here on this crew. So we're going to have this interplay of analysis from all this team to take us through. Of course, we come from different angles of analysis. I've also seen there's a gender angle to this entire aspect as well. Some youth are also looking at it in a different spectrum. We're going to ground all of these on the legal, and then we can take it on from there. Comrades, take your seats, please. But before they commence, I wanted to call in the FOWODE Executive Director to give us some remarks as well. Miss Patricia, sorry to ambush you, but as part of the people who have brought us here today morning, let me a hand clap to Miss Nava, the team who have brought us here. Please. Good morning.
Thank you very much. Good morning, everyone. Good morning. How are we today? Scared, anxious. So my name is Patricia Munabi Babiha. I lead the team at the Forum for Women in Democracy. On behalf of the organizers of this CSO engagement, I would like to welcome you all very much to today's meeting, a critical meeting for us in the sector as we internalize and strategize on what we do with the Protection of Sovereignty Bill. Many of us have been engaged on this bill for quite some time. We got wind of it on the 26th of March when someone in the NRM caucus informed us that the bill was on the agenda for the day at the NRM caucus meeting. And since then, we've been, internalizing the bill, developing different think pieces about the bill, doing analysis of the bill, and, seeing what the intention of this bill could actually be. One thing that we agreed as a strategy, looking at the bill in the form that it was that we deflect the bill from the civil society sector and from NGOs. Why? Because this bill affects each and every citizen in Uganda. When you look at the bill and its detail, I don't know how many of us have actually read that bill. How many of us in this room have read the bill? Okay, this is a good portion. How many of us have told someone else about how bad this bill is? All of us, yes. From our analysis, we said that the only good thing in the bill is its title, the Protection of Sovereignty Bill, because indeed, it is important that our sovereignty as citizens is protected. Beyond that, when you go into the detail of the bill, it is actually horrible. And so, what brings us here today is for those who may not have read the bill to get better detail of what this bill says, and to get an understanding that this bill is about each and every citizen of Uganda. It touches each and every one of us in different ways. And when we go through the analysis, you will actually see that it does. The other question is then to ask ourselves, what do we do in the circumstance in which we find ourselves? We have up to Friday to submit memoranda to the Committee of Defense and Internal Affairs. I'm hoping that one of the outcomes of this meeting will be an agreement that as a sector we submit a memorandum. I would also like to beg that in our memorandum we show that this bill is bad for Uganda, that we deflect it from our sector, that we put ourselves in the place of citizens of this country, and that as we push back and talk to the different decision makers in the committees and wherever, we can make the case that this is a bad law for the country, that we already have a plethora of other laws that actually cater for the gaps that this bill seeks to plug, and that we can, build citizens' voice on the need to actually reject the bill. So I'd like to welcome you all very much once again, and I'm hopeful we will have fruitful deliberations. Thank you.
Okay. Thank you so much, Ms. Patricia. I would like to ask a similar question. How many have read this bill? By show of hands. Okay. How many have deeply read this bill? By show of hands. Like deeply. how many have perused in order to get some section, and then you tie yourself on that? Because this is what advocacy. For you, you have one section only. You're like, this one, yeah, if they ask other things, you say you ask the manager. But this one, I know. How many of you, you're hanging on one section? Okay, so we are here to give you each section. You find something you can rely on. I mean, you can tie yourself on, get to know it deeply. And then for you, if you're asked, you say, for me, I just know this one. Other things, yes, they are there, but I know this one. Such that we have a mixture of views on this. We also want to encourage or to welcome, actually, our online community. And there are some dynamics that are going to run around there of IT. Let me invite the Director of Compliance at CAR to quickly alert us on those small things.
Thank you so much. Good morning. Good morning. It seems I'm the only one affected by the bill. I welcome all of you. Before I will leave the microphone to the legal team, this engagement is for us to share as the sector the recommendations and the comments about the bill. Some of us may get the opportunity to speak using the microphone, but the rest, like the online team, the online audience, may not have the opportunity. So we created a link that we are going to share, that those online can share their comments and recommendations during the presentation or even after the presentation by council. And then the rest of us, the community here in this room, if you get the opportunity to speak, please, you shall speak. We beg to be civil. We beg not to attack. And those that feel like want to have a detailed recommendation, the link will have that option for you to type in the recommendation and the comments. So we shall be sharing the same. And then it has a section that requires, if you wish your name to be included on the submission that we are going to submit, you have to click yes or no. So I think that's all from my team. Allow me to now hand over to the full legal team.
Thank you. My name is Onyango Owor. I work with Onyango and Company Advocates. We are a top-tier firm and have specialization in NGO practice. I think we are one of the few firms that have that separate specialty. I would like to introduce my colleagues, Joel and Winfred, who are going to take us through today's session. Thank you.
Good morning. My name is Namugera Joel Peter. I'm an associate working with Onyango and Company Advocates, and we'll be taking you through this presentation on the potential implications of the National Sovereignty Bill as it has come to be commonly known. I'll be presenting with my colleague Okecha Wilfred, who will be coming in much later on. I believe we all have copies of this presentation, much as it's also projected. Yes. So I saw hands of some people who say they have read the bill and others who haven't. So I'll just try to give a brief background. So this bill, the Protection of Sovereignty Bill, was gazetted on 13th. That was probably on last Monday. And on Wednesday it was tabled before Parliament for the first reading. And in its intentions, as to what the bill says, is to protect the sovereignty of Uganda. So now we'll be looking into whether the bill in its wording actually protects the sovereignty of the country, or it's actually trying to give us something different. We've had different conversations on various platforms where we're analyzing the bill, others in opposition, others in defense. And unfortunately, most who are in the defense of the bill, they only try to give the intention or the perceived intention. But they don't go into the actual bill, the wording, what the wording says. Because when you're interpreting laws, courts always look at what the wording says, not what the person probably intended to. That always comes to the least end. But they always first look at what the bill is saying in itself. So our presentation is focused on what the bill says and what to interpret from that. And the potential implications both to civil society and to Ugandans generally. Because also civil societies, in one of their mandates, they always come up to look into the policies we have, the laws we have, and how they protect our nationals. So it's also a collective duty of civil society to look at the implications of the bill, not just to themselves, but also to the citizens, and also to other stakeholders. So the bill basically is structured in 30 clauses and 5 parts, and these come from the preliminary matters, which is the interpretation and administration, who will be administering the bill. Then the concept of the protection of sovereignty, while naming the prohibited activities, registration, which is very important, of agents of foreigners, as we shall see in the definition, the regulation of funding from foreigners, and as we understand, many of our CSOs are foreign funded, so this is also very instrumental. Then we shall look at the general provisions, which include the inspection and the powers of the minister. Yeah, but precisely, just to give an overview, the bill, like the previous speakers have mentioned, the bill is dangerous worded, and it has a very significant and negative impact on civil society and its operation in Uganda, and also to the citizens and other stakeholders, as we shall be noting down. So the first part of the analysis goes into the problematic, vague, and overly broad definitions. But maybe before I forget, the copies you have highlights of the key clauses of the bill. We also labor to note which provisions are highly risky, which ones have just a significant concern but not much of a burden, and then those that are labeled as law. So take you briefly, before I delve back into the presentation, we have clause 1, which talks about agent of a foreigner, as we shall be delving into. We have foreigners still under clause 1, disruptive activities. We have prohibition.
Just a small interaction here. Comrades, like we had said that the breakfast, it's a breakfast meeting, so we're not going to wait for until when it is done. So I request, like, if, like you can see a table move and then you go and pick something. And then some of our colleagues who have just come in without these coupons, Comrade Sharon is there, putting on black full. She can give you a piece. Please, you move, you pick whatever you want, and then you come back and then we discuss. Thank you.
Yes. Then we have clause 6, which talks about performing active function of the government without cabinet approval. We have clause 7 and 8 that talk about influencing or objecting to government policy. Clause 10, on organizing meetings for promotion of foreign policy. I'm going through them quite fast, but we shall be drawing back to them as we go through the presentation for better clarity. Then clause 11, which talks about influencing electoral activities. Then 13, on economic sabotage. This one is very critical, and I'll draw attention to it when we get that time, because it carries a wide range, not just CSOs. Then 14 to 20 on mandatory registration. Then still 20 on revocation of registration or suspension of the same on suspicion of causing security threat. Then 21, making declarations of funding. 22, the capping of the foreign financing or foreign funding. 23, obtaining funds to engage in destructive activities. Then 25, on the limitations on banks, on when and how to release funds, all foreign remittances. 26, filing returns. 28, inspection by the minister or any officer designated. And 29, permitting the minister to publish regulations activating this act. So returning to our presentation on problematic, vague, and overly broad definitions. Page 2. Yes. So the first definition we have is an agent of a foreigner. Yeah. So according to the bill, one is an agent of a foreigner if they act on the order, request, direction, or control of a foreigner, or whose activities are directly or indirectly supervised, directed, controlled, financed, or subsidized by a foreigner. So this definition largely captures most of our CSOs, if not all. One, because most of them rely on foreign funding. And the definition, it says, provided you're funded by finances coming from a foreigner. It could be direct or indirect. You could be a sub-grantee. You could be even community-based organizations that receive funding from the local organizations. Because these local organizations eventually tap their funding from foreign organizations or donors. So these are also captured as agents of a foreigner. Then you also have individuals employed. If you're employed by CSO, you're also an agent of a foreigner. Why? Because they're talking about indirectly controlled. When you receive funding from a donor, I believe when you're making presentations, you indicate what you're going to use that money for. Yeah? And perhaps the donor could also make some alterations on directing how you should actually use that money. And who implements this? The officers of the organization. So you're working indirectly on the orders or the command of a foreigner. That makes you an agent of a foreigner. And as we shall see, there is a requirement of registration, which means not just the CSOs must register, but also their employees. Then we have academic and research institutions. These that conduct research, they receive funding to conduct research, even CSOs. Many of them release reports and all that. Yeah? So considering that you're receiving funding from a foreigner, whether direct funds or in kind, you're an agent of a foreigner. There have been broad discussions that also include many other scopes of people if you are to go into individuals. If I'm a student, I'm on a scholarship from a foreign organization, I'm an agent of a foreigner. Because my studies are financed by a foreign entity. Yeah? I'm receiving money from a brother abroad. I become an agent of a foreigner, as we are going to see on who is a foreigner. So that is it with an agent of a foreigner. We shall be carrying back as the presentation goes. We also have journalists. If they are carrying, if the media station is advertising for foreign entity, even if an international organization, for example, has an event in Uganda, they pay for advertising the event to the media station. The media station is receiving money from this organization, foreign money. That makes the media organization or media entity an agent of a foreigner. And so are the journalists that are working up, the ones that are covering an event. You get? Yes. So the definition is broad. It doesn't have exemptions. It has no limitations on who is excluded, which is very dangerous. And precisely, it curtails most, if not all, CSOs. Then the next is a foreigner, still under clause 1. Who is a foreigner? A foreigner includes a non-Ugandan citizen, a Ugandan citizen residing abroad. You should pay more attention to that. Foreign governments and diplomatic missions, corporations, all NGOs registered outside Uganda, international or multinational organizations, and critically, any person, institution, or body that the minister may, by statutory instrument, declare to be a foreigner. So a minister can decide that you're a foreigner, even if you think you're not. That's also one of the problems we have with the definition. Then the other problem is with Ugandan residing abroad. We know how someone becomes a citizen and how they lose their citizenship. Yeah? Now the bill is trying to override what the Constitution says on citizenship. It's saying, if you leave the country, you're becoming a foreigner. And as we shall see later on, this is a discrimination on grounds of exercising your right to movement, because you have a right to move outside the country and back. So if the government is deciding that on you leaving the country, you become a non-citizen or a foreigner by this bill, that's a ground of discrimination and also another problem. And it also has further implications. Now, what are the other implications? Majority of the people leaving the country through foreign recruitment agencies are youth. Yeah? The high rate of labor migration. We have a big problem of unemployment that government has failed to solve, as you could say. And, not out of their willingness, many Ugandans are forced to leave the country in search for greener pastures. But after they leave, government is coming up and saying, when you leave the country or when you stay outside the country, we are labeling you as a foreigner. And any finances that you'll be remitting back to the country, we have an oversight on them. We shouldn't also forget that these Ugandans, the money they work or they get from abroad is remitted back into the economy. So labeling them as foreigners and putting overly unreasonable restrictions will impact our economy and perhaps discourage people from leaving and tie themselves into the unemployment problem that we have. Then the other is allowing the minister, giving the minister overbroad powers to decide who is a foreigner and who is not. Yeah? We will find that now this power could be used by government, by the state, for political ambitions, labeling opposers to government as foreigners and what have you. So it's also a very big problem with the bill. Then the impact this definition will have on women. Most of the women in the country, or many of them, are beneficiaries from foreign remittances. Some have husbands abroad or relatives who send them money they invest into their small businesses, and others are beneficiaries to CSO programs, maternal health, and among others. So these restrictions and largely the bill itself will have an impact on women. With the restriction it has on receiving funds from banks, you have to present proof of registration, as we'll see here. And these, in the end, limit or go contrary to government policy of uplifting women, and also violate some of the, in the end, will end up being contrary to some of Yes. Then to the elderly, still same thing applies. The elderly are beneficiaries of foreign remittances, so you're having an elderly who needs money to take care of herself, being required to present proof of registration before receiving funds from the bank. Yeah? Perhaps the money is even for an emergency. So that's another problem. Then still with children, as I mentioned earlier, if I'm a student on a scholarship, I become an agent of a foreigner. So you're imposing restrictions on receiving money upon registration and the capping. So in the end, this will have an impact on children, not just on receiving money for school fees, but also the different programs that target children by these CSOs. Then you have disruptive activities. Now this one has a broad definition, but precisely it includes acts threatening national security, violence, destruction of property, employing persons to promote foreign interests. Now this captures all employees of CSOs because you're promoting foreign interests. Yeah? And it's an offense. So you're committing an offense by practicing engagement activities. Participation in unlawful demonstrations. Yeah? So, yes. And precisely talks about disrupting business activities. So if you have a CSO that has advocacy that perhaps a labor action targeting a partial employer who is violating rights of their employees or disrupting their activities, you're committing an offense. Yeah? So that's also a very big problem. Then interests of Ugandans. The bill talks about promoting interests of a foreigner against interests of a Ugandan, but it doesn't talk about what are the interests of the Ugandan. Are they interests of the government? Are they interests in because we are supposed to decide what our interests are. Yeah. So if government is going to set for us what the interests of Uganda are, and also not defining this in the bill, that's also another problem, which gives it a leeway to include anything they deem fit to be against the interests of Ugandans. Then we'll go to part 3 of the presentation, and maybe just to note, many of these are highlights. Those that have read the bill could have additional supplements that could perhaps not have been captured. At the end of the session, we'll be having an interaction where you bring out those and we boost, because this is a collective contribution. Yes, so part 3, we are looking at problematic clauses and analyzing them. We have prohibition on policy influence. Yeah. So the bill makes it an offense for you to influence government policy or sponsor opposition of government policy without approval of cabinet. If you understand that what that means, just to simplify it, one of the duties of civil society is to shape or help government shape policy. But now it's making it an offense to influence policy without their approval. So it's curtailing the freedom of expression, as we will see much later on, among others. If you're submitting a policy paper, if you're presenting a research, actually we are already trying to influence government policy here. So if the bill was already passed, we would be committing an offense. Then prohibition of electoral interference. It also says if you influence how the will of the people is to be determined, you're committing an offense. Yeah? But it does not curtail in which way. If I'm training citizens on how to vote, yeah, among others, will it be electoral interference? The provision has only one exception, which is to people who have been nominated to participate in the election, which is very thin, because we have very many players in the electoral system. And as we shall say at the end, we shall be having recommendations for some of these things in the alternative. Then economic sabotage under clause 13. This is a very problematic clause. The clause says, if you publish something, and publishing has been defined to be in a lot of ways. You could be on radio speaking, you could publish a paper, you could write your article, that is all publishing. Yeah? So if you publish something and ends up causing economic disruption or interfering with national security or the viability of a country, you've committed an offense. Why is this problematic? It does not look at whether, one, what you've published is true or not. It just looks at the impact. Then 2, it gives the leeway with government to determine what is deemed to be a disruption. Yeah? So it can be used for economic reasons to fight efforts to shape the country's economy or even policy. Yeah? And as we will be seeing, this offends the principle of legality because it's, first of all, broad but also vague in its wording. Then we also have clause 14 to 20, which provides for registration. As I mentioned earlier, if you know you qualify as an agent of a foreigner, you're required to register with the minister. And on registration, you present a number of details or information, from contracts, sources of funding, assessments as to identity, character, and physical health of the directors or applicants, etc. Yeah? So you make full financial disclosure and full disclosure of all your activities, which is very problematic because I understand that in some of the agreements you sign with donors, some of them have clauses. Yeah? There's particular information that could not be relayed. And what makes it very problematic is not just this, is the fact that it's available to the public for inspection upon payment of a fee. So the donor funding agreement you have can be accessed by a one Joel out there who wants to see what Civic Advisory Hub is doing, which may injure a lot, either beneficiaries or even the donors, because we understand some donors may provide funding in confidence, provided the funding and the activities intended to be funded are legitimate activities. And this same registration regime gives the minister the authority to suspend or revoke your registration. Now, the registration is valid for 2 years, but the minister can revoke it at any time, provided he deems that you pose a security threat. Now, what is a security threat? We don't know. That is up to the minister. That is another problem. And it gives no recourse once your certificate is suspended or revoked. It does not give a remedy. So what happens to your activities? And remember, we have an NGO Act where you're registered and you're allowed to practice as a CSO or an NGO. But now this registration is trying to override the authorization of the NGO Bureau, which is giving a permit to operate. So what happens if the certificate is revoked? Then also, we have the funding cap, the foreign funding cap. Clause 22 provides for a cap of 400 million. If you're to receive an amount equating to 400 million within 12 months, anything beyond that, you must seek approval from the minister. And if you receive that money onto your bank account, the bank will not remit it to you, will not release it to you until you present approval from the minister. Now, we understand that many NGOs or CSOs operate on budgets beyond this amount, which means you're going to have activities put on standstill because you're waiting for the minister's approval. And the bill does not provide for a time limit within which this approval is to be provided, which means you'll have your application for approval submitted to the minister and you'll sit and wait without knowing when the approval should come in, which will put activities of CSOs on standstill and disrupt, and also, most importantly, put the beneficiaries at risk of losing out to the programs of these NGOs because they are waiting for approval from the minister. And in addition to that now, as I mentioned, we have emergency funds that are supposed to help us with particular activities. Yeah? Program has run out of funding, you need some emergent funds. But the funds perhaps exceed this cap. It means you cannot inject them into the program until the minister approves. So the program will come to a standstill, it will entirely halt. if the delay injures it to that effect. And this also goes back now to the citizens. If I'm required to have registered with the minister as an agent of a foreigner, and yet I need this foreign remittance for an emergency, the bank asks me for proof of registration and I don't have it, it means I have to first run to the minister to register. I don't know how long the process is supposed to take. If I need funds for a surgery, the hospital says we are not touching it until you make our payment. I have to wait for the registration to be complete. That is another risk. Then we have declaration and reporting under clause 21, 24, 25, and 26. We are supposed to report the activities you have done, the funds you've used, and how you've used them, among others. Yeah? The disclosure required is overly broad. There is too much information required, which could endanger beneficiaries and the donors. Yeah? So that's another problem. We also have data protection at the data protection side, where how this data is supposed to be protected, and comparing that the amount of information that is required is a lot, it endangers CSOs violating their obligations under the Data Protection Act, and perhaps the GDPR in case where you have citizens from Europe, because that's what governs data handling for their end, and the CSOs that have their data are also bound by those obligations. Then clause 28 gives the minister power to inspect at any time. A warrant-free inspection. Now, this is problematic because in most instances, inspections are supposed to be guardrailed with either judicial approval, oversight, etc. So at this rate, the bill is exposing CSOs and the information they have to the handling of government as it wishes. So if government wants to, we always say if they want to inspect a building, there's a right to freedom from unlawful entry or such. Yeah, so they are trying to go around it and give the minister power to inspect at any time where they want without notice, and do whatever they want, ask for what they want, etc. Which is a very big problem with the bill. Then we have penalties that are non-proportionate to the offenses. They are overly prohibitive, because you have, for example, you have the offense of promoting foreign interests. Yeah? If it's a person, you can be fined 2 billion shillings. And remember, I mentioned that the definition is broad for promoting foreign interests. It includes practicing the legitimate activities by these CSOs or even other people. Now it's an offense here, and you have a penalty of a fine of 2 billion or 20 years of imprisonment, or both. And for an organization, 4 billion. That is a full budget that can be paid in a fine. We have being unregistered. If you are not registered and you receive foreign funding, you work on it without being registered. For a person, it's 1 billion or 10 years imprisonment. Then exercising government functions without approval, still 2 billion or 20 years. Yeah? Receiving unauthorized foreign funding, if you receive more than the capped amount without approval from the minister, you are liable to a fine of 2 billion or 20 years. Plus forfeiture. The government will take this money. It will forfeit it. So when you proceed to use this money or receive foreign funding without approval, you're risking the government taking this money. That's another problem. Because why is the government taking the money? Yeah. For an organization or a corporate entity, it's 4 billion plus forfeiture. So precisely, these penalties are disproportionately severe and constitute a profound effect on CSOs because most of the activities that are made offenses fall within the legitimate activities of CSOs. So they'll only be trying to curtail CSOs from practicing their activities, legitimate activities that they have been authorized to practice by the NGO Bureau, by the permit that is issued. Because the NGO Bureau inspects the activities you're going to conduct. The funding, what's your source of funding? You provide all this information and it permits you to operate. And now you come here and we have blocks being put on how you can proceed. Then the other part is on constitutional violations in this bill. One is the freedom of association. This is provided for under Article 29. You have a freedom to join a civil society, join associations, yeah. So the offenses that are placed on through the civil society and the activities, the legitimate activities they're supposed to practice, comes as a guardrail to the freedom of association. And as you've seen, it's not to say that these freedoms are non-derogable. They can be limited, but the limitation must be reasonable. There is a test. The Constitutional Court has given a test on where we are making restrictions to the right to freedom of association. The Human Rights Network, Uganda case versus Attorney General, says restrictions to the right to freedom of association must satisfy the test of necessity and proportionality. They must pursue a legitimate aim, be necessary in a democratic society, and be proportionate to that aim. Now, in our understanding, these restrictions are not proportionate and they are not required. They are not trying to. They are not achieving what the government is saying they want to achieve with this bill. And like someone said, perhaps the only intention the bill, the only thing in the bill that tries to portray the intention it's intended to is the title itself. But beyond it, all the other clauses are contrary to that. They are giving a different impression. Then the other aspect is the freedom of expression. As you've seen, various prohibitions within this, influencing government policy, publishing information that could be seen to, that could amount to causing economic sabotage, meetings that are intended to influence government policy, all seem to be trying to infringe the right to freedom of expression that is guaranteed under Article 29. And we've had court decisions still on this. The Charles Onyango case says it admits that this freedom or this right can be limited, yeah? But there is a line of limitation that has to be made. The state cannot just criminalize anything that they deem they don't want or is not in line with what they want. Because as players in the system, we all have our different obligations. Government plays its part, civil society plays its part, the citizens play their part. So if government is trying to criminalize legitimate activities of CSOs, like influencing government policy, yeah, that is already trying to infringe on the freedom of expression, which is contrary to the Constitution, all in contravention with Article 29. And also, most importantly, the Charles Onyango case was about Section 50 of the Penal Code, which was on publishing false news, yeah, and it was deemed to be an unreasonable restraint to the right to the freedom of expression. Now the government tries to bring this restriction back through a back door in a different way, where they're saying if you publish anything and they deem it to be causing economic disruption, national security, yeah, you've committed an offense, which is unreasonable, an unreasonable restraint, and also a very overly broad and unreasonable offense in its phrasing or drafting. The other freedom is the freedom of assembly and demonstration. And Article 29, 1D, we have a right to assemble and demonstrate lawfully. Yeah? But now the bill is saying, if you influence any meeting that is intended to object or oppose government policy, or any activity that opposes government policy, you're committing an offense. So this is another restriction to the freedom of assembly and demonstration. Now we've had cases. We had the Human Rights Network case versus Attorney General and the Mwanga Chivumbi case, which nullified provisions, the Public Order Management Act and the Police Act, that gave the police powers to discretionarily block public assembly or public gatherings. Now in this case, we are having government saying you cannot influence or fund a meeting that is intended to oppose government policy or influence government policy, because influencing is also in different ways. We can choose to peacefully demonstrate a particular law that is going to be passed. That is already trying to influence government policy. But then the bill is saying you must have approval from cabinet, which is an unreasonable restraint or restriction to the freedom of assembly and demonstration. Then we have the right to privacy. As I mentioned earlier, the bill gives the minister a warrant-free access to inspect your offices, your information, and etc. And also, the registration regime requires you to provide a lot of information that could be relevant, or some of which has confidentiality bearings and does not guide on how this information should be handled. But also, more still, makes it accessible to the public upon payment of a fee. Now, some of these details, as I earlier mentioned, include personal data of beneficiaries, of donors. All this information is likely to be exposed, violating the right to privacy of these people. And also to the association. The association itself also has these rights in communion with its directors and its members, because this information is held bearing in community with its members. Then we have the rule of law and principle of legality. Now, Article 28, 12 of the Constitution provides that no person shall be convicted of a criminal offense unless the offense is defined and the penalty prescribed by law. Now, the problem we have with most of these offenses, or some of the offenses, is they are overly broad. Yeah? They don't tell you what of your activities may be a disruptive activity. Or if I do this, will I be in contravention with the law? Yeah? Which gives the states the discretion to determine that what you've done constitutes a what? A disruptive activity, constitutes so and so. So you are in contravention with this law, and we are fining you 2 billion. Or 4 billion. Only prison you for 20 years. So, in an instance where you are having penalties that are very huge, the least you can do is provide a very clear definition of these offenses for the citizens, for the entities to know what falls here, what doesn't fall here, and not leaving room for speculation. And still, as the Charles Onyango book case had mentioned when discussing or when determining the unconstitutionality of Section 50 of the Penal Code, Justice Mulenga mentioned that a law that lacks sufficient guidance on what is and what is not permitted, giving the state unfettered discretion to determine from time to time what constitutes a criminal offense, cannot be acceptable and is not justifiable in a free and democratic society. So many of the offenses we have are overly broad and vague, which leaves room for speculation, also giving the state the discretion to determine what is an offense and what is not, because the bill does not clearly state what is and what is not, which offends the principle of legality. So the next part after that tries to give a highlight of the constitutional rights that are at risk, in line with what I've discussed. So my colleague will be taking on to the next part regarding regulatory duplication and over-regulation. Thank you.
Thank you, Joel. Good morning, members. My name is Okesho Wilfred, as earlier introduced. I'm a tax and legal associate at Unyang and Company Advocates. I'll be continuing with where my colleague Joel stopped. The next point of discussion is the regulatory duplication and then over-regulation. Been informed that there are some technical challenges with displaying. So, since we all have the write-up, now we see that the already existing laws that regulate the NGO sector, the civil society organization, etc., etc. But with the proposed enactment of this law, we feel like the sector will be over-regulated. There is the NGO Act, together with the regulations. Now, this law established the NGO Bureau. The NGO Bureau is mandated with the oversight of the NGO activities in Uganda. So this oversight runs or stretches to the activities of the NGO sector in Uganda. If Civic Hub in Uganda is operating, it must first require or acquire a permit from the NGO Bureau. Now, with the enactment of this law again, which again is calling upon Civic Hub to again register or get a permit with the Department of Peace and Security under the Internal Affairs Ministry, we see that there will be a duplication of the laws, because there is already an existing law that is requiring Civic Hub to acquire a permit before it commences its operations in Uganda. So we also have the Penal Code Act. This law penalizes, among others, actions that are calculated to bring the government into hatred or contempt. Now, Joel has given us the broad definitions of some of these perceived actions or that have been criminalized under this proposed bill. So, with the existence of the Penal Code Act, and again you're enacting a new law to still criminalize the actions that already criminalized under the existing law of the Penal Code Act. That's also a duplication. Then the other existing law is the Anti-Money Laundering Act. Under the Anti-Money Laundering Act, there is the FIA, the Financial Intelligence Authority. This authority oversees financial flows of every entity, be it a school, be it an NGO, be it a limited liability company, the financial overflows of that specific company or NGO are overseen by the FIA. Now, this law also proposes, or you see that it goes ahead or it goes in depth to oversee the financial inflows of the existing NGOs in Uganda. So for us, we feel that this is also a duplication of the existing law. Then we also have the Income Tax Act, which of course are for NGOs in Uganda. If you want to be exempt from income tax, because NGOs are, as we all know, that they do not generate income. So if you want to be exempt from income tax, you have to present the sources of your funding. That I'm receiving this funding from sources A, B, C, and D. Now, with the presence of this law, and then also the enactment of this bill, if it's passed into law, we shall be seeing that two laws are being, a law that is already in place is being duplicated. There's also the aspect of dual registration. Under the NGO Act and the regulations, for an NGO to operate, it must be registered. In other words, it must have a valid permit to operate. So, the bill also calls upon the NGO to register with the Department of Peace and Security, which is under the Ministry of Internal Affairs, to also acquire a permit to operate. So, you have a permit under the NGO Act, issued under the NGO Act. You also now require to have a permit issued under the proposed bill. So, we shall have to weigh which one supersedes the other, which one is valid, which one is invalid. So, dual reporting. Now, NGOs or this civil society organization have to report with the NGO Bureau currently, because that's the existing law. But also, under this proposed bill, the NGOs will have to report to the Department of Peace and Security annually, just like it is. During investigation, the NGO Bureau has powers to investigate activities of NGOs. Still, even this bill is proposing that the Department of Peace and Security has the powers to investigate the activities. We'll move to risks of driving funds into unregulated sectors. So, there is a risk that if this law has been enacted into an act of parliament, the NGOs or the CSOs will try or will attempt to derive their funding through unregulated sources. How? Let me give an example. Those of us who are conversant with the gaming and betting sector, there are laws in existence that bars players from placing bets or from playing casinos, with operators that are not regulated by the National Gaming and Regulatory Board. However, there is a report that was recently issued that found that 25% of the funds under the gaming and regulatory sector was through unlicensed means. People place bets with operators who are not licensed. How they do it, no one knows. So there's also a risk that with over-regulation of the NGO sector, the NGOs will have to run to unregulated sources. For example, the informal value transfer systems, diaspora remittance channels. Joel has explained that if I have a brother abroad, but then they are sending or they are remitting money to me here in Uganda, now, if I'm registered, the NGOs can pass through my brother who is abroad, as if they are remitting money to me, and then I disperse that money to the NGO. So you see that that's already an informal way of receiving cash here in Uganda. Then cryptocurrency and digital assets currently in Uganda, we don't have a law regulating cryptocurrency or digital asset transactions in Uganda. So you find that there is a risk that funds could be passed through these channels as well. Now, I'll go to the recommendations straight. To those who have read the bill in depth, the overall recommendation would be that the bill should be dropped. In other words, Parliament should not even attempt passing it. That could be the overall recommendation anyone who have read and understood the bill would give. Because I was discussing with my colleague Joel on Monday that I have a neighbor who is in the banking sector. He came to me on Sunday. For him, he was quiet until their legal officer alerted them about the bill. So he came to me to get my views. I told him, you see, this bill is affecting everyone. Even your grandmother deep in Uganda is affected. How? If today you leave your employment with KCB Bank and you go abroad, then maybe your grandmother has a health emergency, just like Joel, the example he gave. You're sending money to her to get a surgery. But if your grandmother is not registered with the ministry, it means she will not be able to receive that money. Even the ministry or the government has powers to forfeit that money that has been sent. So you could be seated, but you don't know that if this bill is passed into law, it's biting each and every one. Every sector is affected. Banking, construction, engineering, every sector is affected. It's not only the NGO sector, as we are discussing today. Even, actually, it's reminding me that even as lawyers, because we have international clients. So a client who is sending professional fees to Onyang and Company Advocates, Onyang and Company Advocates must be registered with the Department of Peace to receive that money. So if we are not registered, we find the client has disbursed the money, he wants his work to be done, we have not received the money, the government has even forfeited it. So everyone is affected. So that's the only recommendation that is there. But from our point of view, as lawyers who read the bill in depth, we have further recommendations. And I think just like Lutaya said, it's an interactive session whereby we shall have other recommendations from the audience. For me, or from Onyang and Company Advocates, who worked on this analysis, we also came up with further recommendations. One, to narrow the definition of agent of a foreigner to explicitly exclude charitable, humanitarian, and development organizations not engaged in partisan electoral activities. That is one of our recommendations. The second one is to remove the minister's power under clause 1, paragraph F, to declare entities to be foreigners by statutory instrument. If you recall when Joel was giving us the definition of a foreigner and agent of a foreigner, so the minister has unfettered powers to declare that you're a foreigner. There's no criteria the minister should follow, but if you are not, maybe you have annoyed him today, the following day, this is a statutory instrument that has passed by the Minister of Internal Affairs declaring the following people or entities as foreigners, and that's it. That's it. Once you're declared, colors. 3, we recommend that there is an introduction of a statutory timeline for ministerial approval of foreign funding applications. So the previous discussant told us that you have to apply to be eligible to receive this funding from foreigners. Now, the bill as it is right now, it does not define when will your application be determined. It's blank. So it could take even a year. Now, we understand that majority of the NGOs work on timelines. You may be implementing a project in Soroti, whereby the contract is for 6 months. So you're not certain when will the minister approve your application. So we recommend that that at least a period of 30 days is put as the maximum, and after the 30 days have collapsed, if you have not received an approval from the minister, it's automatic that your application has been approved. The fourth is establishment of an independent appeals tribunal or body for all registrations and funding approval decisions. So the bill as it is at the moment, once the minister makes a decision, you do not have a right of appeal, or there is no mechanism of appealing that decision once you're satisfied with it. For example, you've made an application for a foreign agent, but the minister has refused it. There is no mechanism of appealing that decision. The only recourse you could have is through judicial review by way of filing an application in court. So, for the lawyers in this room, you know how time-consuming it is to litigate. You're not sure. I think the shortest you can receive a ruling or judgment from court, if you're so lucky, you can give yourself 2 years. Now, just imagine you are receiving funds to implement a project of within 6 months. But now you're going to court to appeal a decision of a minister, and then the ruling is given 2 years later. So that means that there's no purpose. No purpose has been served. So we recommend an establishment of an appeals tribunal. The other is to repeal or to substantially narrow clause 13. When Joel was giving us his introductory remarks, he said that he will be giving much emphasis on economic sabotage. So, we recommend that this clause is repealed or narrowed to include a specific and express intent element. The principle of legality. We know that before you are convicted of an offense, there must be an act and a mens rea, or the intention to commit that offense. So, when you look at clause 13, for you to be declared to be, for you to be convicted of economic sabotage, there's no need of intent. So it doesn't matter whether the publication you've made is positive or negative. There's no requirement of intent. The minister will just declare that your publication has an impact on economic sabotage. So the penalty of not more than 2 billion is imposed. Then we also recommend harmonizing the bill with the NGO Act to avoid overlapping powers between regulators. So we are seeing that, of course, the primary law regulating the NGO sector is the NGO. Okay. So we also recommend to expressly exempt from the scope of the bill UN agencies and their implementing partner organizations. And their implementing partners, organizations delivering humanitarian assistance, organizations operating under bilateral government-to-government agreements, and then academic and research institutions. We also recommend to align the funding oversight mechanism with the FATFS. So FAT is a financial action. So we recommend that that the bill is aligned with this best approach, targeting organizations identified through intelligence-led assessments. We also recommend removing the warrant-free inspection. We understand that from Joel's discussion that under the bill, the minister has powers, unfettered powers, to just come into this building to inspect whether your operations, everything. So we recommend that this unfettered powers is removed, and it's replaced with at least a warrant, which could be issued by a magistrate. Then the other recommendation is on to raise the threshold, the funding cap. From the bill, the maximum you can receive in a year, 12 months, is 500 million. Majority of the NGOs operate beyond that budget. So we recommend that the cap is raised. Then the last recommendation would be on so the last recommendation would be to curtail the powers of the minister under the bill as it is. So we know that we have heard that under the bill, the minister has the discretion to revoke or suspend your license. So the reason that has been given is very vague for security threats. There's no term under the bill called security threats has been defined. So it's upon the minister to form his own opinion that what this organization is doing is a security threat. So I'm revoking your license or I'm revoking your permit, and that's all. We have already noted that there is no mechanism of appeal under the bill. So our recommendation is that this ministerial power is removed or curtailed.
Yeah, and maybe to seal it up, before we go into the contributions, the general overview or the general recommendation is that the bill is vague, overly broad, and a danger to civil society operation, and we should draw our attention to it and join forces into bringing our concerns to, all your concerns to the Parliament through your views and through some of the aspects we've jotted down, and also sharing some of the things that you think we've not noted. For example, we have international conventions, humanitarian conventions, that some provisions of this bill are intending to offend, and yet government has ratified them. So all those are concerns we should draw our attention to and bring to the attention of Parliament. Thank you. I think we'll be taken into the segment of the contributions and reactions to the presentation.
Thank you so much. Another, but I just said another, then you clap. So you mean I meant what? Another hand clap. Nice to see you, Robert. Yeah. So actually I can see we can even leave earlier than planned. Now, in this session, there are two aspects that we really want to capture. Further strengthening what the comrades have shared. Either thematically, you can say maybe we capture this and this, maybe this, the question on gender is less, something of that sort. I would discourage, you taking the mic and then you say, now we won't fundraise. For example, for me, I have a budget of 1 billion. Now when you put me at 4, that we know, like they have said, okay, that caption is a problem for everyone. So anything that strengthens this discussion, something that was missed, seen in another angle, and perhaps strategy. Then I also appreciate colleagues who are coming from up country who have done, other campaigns. They could share with us what they have done there, and we join the fray. Such that the contributions are succinct and to the point, and they help the comrades here to put whatever they would want to include. We also are live to another analysis from JAP as well as FOWODE, and I have asked comrades to also be share with them at a later stage. Then the colleagues who are online, you'll have an opportunity to type and put what you want to say, and then we can capture it and then say it loud here for others to hear. Can we use an hour strategically? And then anything that is mingling around, we can use the 30 minutes, and then at midday, we can be off from here, of course, with strategy. I also want to welcome Robert, who has joined us. Most of us are members of the coalition, and the coalition is on a vacation, forced vacation, but they'll be back soon. You're welcome, Rob. Thank you for coming, despite all. Let's give Robert a hand clap. All of us are members there, majority of us. Yes. So let me now take views with this caveat that I've said. Something robust, that let's strengthen this part, bring in this angle, look at this section. For example, I didn't hear section 38, which is really our mother section. I mean article 38, which is our mother article. So that bit that preaches it, the fact that when you talk about influencing policy, because Article 38 says you'll influence policy. But then you're saying we can't influence policy, yet it's a constitutional right. So such things, and then we make this beef up. But for the start, let me look FOWODE, who have, is there another mic? Oh, we are going to come here. Can we have another mic, such that people don't move? He had moved already, but you could come. You could come. Yes.
Hope it does. A very good morning to everyone in your specific attendances here. Joseph Kateriga is my name. I'm a legal program associate at Justice Access Point. I thank my colleagues from Onyango Advocates who have actually simplified my work. So I'm simply going to talk about the potential implications and areas of concern for specifically the civil society organizations and specifically in Uganda. Yes. So the bill has clearly been identified and discussed to the fact that it has a memorandum actually. The very first introduction of this bill, if you've read this bill in its entirety, it has a memorandum. Under this memorandum, it's actually going to bring out the objectives of the bill, the defects in the law, and what they propose to be done. So we realize that this bill is basically framed as a safeguard of Uganda's sovereignty, which is under Article 1 of the 1995 Constitution. It's on that note that we actually realize that actually Uganda has beautiful laws, but I would like to assume that our beautiful government is also not aware of the laws that we have. So I'm going to look at, please, let's go to the second. Yes. No, not sure that. So I'm going to term this, still on the first slide, I'm going to term this, my presentation, as a sovereignty development paradox. That's how I'm going to look at it. Because looking at the implications to the civil society economically, we realize that civil society has literally been vital, or has literally been a vital engines to service delivery and resilience. And we realize that a lot of sources come through the civil society and always channeled to various service deliveries through health and many activities that are being done by all the civil societies that are here. And how else is it bringing out this sovereignty development paradox? We are going to look at the fact that there are partnerships that these various civil societies have actually done. And these various partnerships have actually fostered innovation and accountability. And actually, if you realize, this bill is actually going to check all that. When you look at the economic side of it, it impacts the social side of it. So that means this bill is going to bring about an implication of something that we would term as social disruptions or stratification. What am I trying to say? We are going to look at a future, if in the event that this bill is actually passed, we are going to look at a future where most NGOs or civil society organizations are actually going to sit back and relax. Yes. And looking at the political perspective, or something I would term as the political reclassification of this bill, would look at actually us citizens being turned to subjects. Now, for this matter, I will draw us to an analysis by Mr. Mamdan. It's an analysis by Mamdan. This is called a bifurcated state analysis. What does this analysis literally bring about? Remember, this bill presents an aspect of agents, of presenting actually civil societies as agents or foreigners, but actually this actually strips us off our status as from autonomous political participants to rather foreigners in our own country. So at the end of the day, you're going to realize that it creates a hollow sovereignty state, or something that you would call a dependent variable. How is this going to be brought about? If you make some research and you get informed about Krasner's concept of organized hypocrisy, you're going to realize that actually this is what this bill is presenting before us today. What does this concept talk about? This concept brings about the aspect of actually more surveillance than rather we are actually going to be in a state where the state actually there is more surveillance by the state rather than promoting more development by the state. So that's what I'm looking at. So now allow me look at each clause. Since they have been ably discussed, I'm just going to look at their impact and the political economic impact initially. Is that okay? So let's go straight up to clause 1. Yes. So we are going to realize that our analysis basically combine both a legal, human rights, and political economy perspectives. And these are going to bring about the bill's risks that create a hollow sovereignty, or something that you would call formal independency without substantive capacity to deliver welfare. So clause 1 has ably been discussed by the legal team. So what impact does it bring? Looking at the human rights perspective, you're going to realize that Article 21 is violated, as it actually stigmatizes ordinary Ugandans. And looking at it in the political and economical analysis, we are going to realize that it actually reclassifies citizens as subjects, basically a stripping agency. And when we look at, now that's clause 1 that actually brings out the various definitions to what it is, to some of the terms that this bill talks about. Whereas looking at clause 2 that talks about the application, how this bill is going to be applied in this country, in the event that it is put into action or it is enacted, we are going to look at the fact that it's criminalizing influences or influencing stroke opposing government policy. That is something that has really been ably discussed. So what is the impact we have? As I told you, Uganda has beautiful laws that seem to be not known by the state. We look at Article 38 in the Constitution of Uganda that clearly talks about participation of citizens in government affairs. And what is the political economic aspect out of this? We are going to look at the fact that there's going to be a monopoly in regards to the policy space. Remember, doing any activity that is in line or that is is basically contradicting what they would consider contradicting the government's policies is infringing, it's threatening the security of the state. So I feel like the policy space has been monopolized, and it actually also excludes independent research. As through application of this bill, all this is going to be criminalized. So looking at clause 3, let's go to clause 3. So clause 3 to clause 4 literally brings out the administration of this bill. That has been discussed. So what is the impact of this administration? We realize that actually the bill was drafted by very good people, but we realized that they actually placed all the authority, all the regulations under the Ministry of Internal Affairs, Security Department. The question is there any oversight? Are there any safeguards risking to abuse of this? That's something I'll let you answer. And when we look at the political economic perspective of it, we realize that civil society has been securitized. We are looking at treating NGOs as actually security threats rather than development partners. That's going to be the impact from the administrative clauses 3 and 4. So let's look at part 2. Oh, actually, I'm sorry, this bill is framed in 5 parts. You're going to see part 1, part 2, part 3, up to part 5. So under part 2, it discusses the protection of sovereignty, as well stated by the bill, and this has clauses from 5 to 13. Looking at clause 5 that brings out the sovereignty of the people, the same that is actually in Article 1 of the 1995 Constitution, we realize that's where they bring out the aspect of them actually criminalizing what you would consider promoting foreign interests. Where does that leave us? Where does that leave civil society? We see the need in society and we try to work it out. We come out there to try and protect human rights. We try to prevent atrocity crimes. But now, we are promoting foreign interests rather than looking at development of our nation. So what is this impact that is going to come as a result of this? We are looking at the violation of Article 28. That is the principle of legality. You get? Because this leaves an ambiguous state. We really don't know what is considered lawful, what is considered unlawful. It basically opens a space for arbitrary enforcement or selfish interests by the state in this state, because we civil society, of course, cannot implement anything. And what is the political economic perspective in this? It's basically we are going to see sovereignty reframed as insulation rather not empowering, something that overshadows or shrinks the civic space. So I'll rush through clause 6 that identifies the exercising of the government functions. So actually, once this bill is brought into enactment, it bars NGOs from operating or doing any services without cabinet approval. Right now, we could come here and actually advocate for such things, but in the event that this bill is enacted, we shall be committing a crime. So what is the impact we are looking at? They are threatening schools, hospitals, humanitarian aid. And this is actually going to create unfunded mandates, as NGOs will eventually withdraw from such, to avoid such deregistration circumstances, because right now NGOs are still healing from the fact that any moment they can come for you. Any moment. And it's funny that we thought we could identify the loopholes in the NGO Act or regulations. Now there is another bill that is going to affect that. Let's go to clauses 7 and 8. These actually bring about policy development and implementation. It actually identifies the fact that only the cabinet can develop or implement policies. So civil societies that have actually been strong pillars in this development sector have actually been sidelines. You get? That's what has been noted, that advocacy is going to be criminalized now once this bill comes into play. So what is the political economic aspect out of this? We realize that this produces epistemic closure, knowledge filtered through the executive. Looking at clauses 9 and 10, these bring about the foreign policy. We realize that meetings actually that are prompting foreign policies are criminalized, more so if they are not adopted by the cabinet. Yes, and what is the impact of this? As earlier noted, that civil societies, NGOs, even CBOs, we have literally been receiving funding and leading to the development, innovations, and comparative learning of society. This has been checked. This is yet to be checked. That's the right term. And so basically realize that this restricts international cooperation, which will lead to Uganda being isolated. The beauty of it is that most of us here are civil society members. You realize that now most of the calls out there, a donor that was once funding Uganda curves the funding bracket. You will find that funding is only left to Kenya, Tanzania, and Uganda is always sidelined out of it. So this is what it's going to do. So looking at clause 11, those are the electoral policies. They were discussed, however, and yeah, it violates Article 59 that has been discussed. However, this weakens the legitimacy by disenfranchising all the various Ugandans who are abroad. Because remember, if you look at clause 1, it discusses who is a foreigner. And if you look at who is a foreigner, everyone in diaspora is a foreigner now. They are no longer people who would consider citizens of Uganda. So there is some weakening of the legitimacy in this bill, if enacted. Looking at clause 12, we are going to look at government operations. Any meetings that are going to be done by civil society that actually interfere with the government or advocate for anything in relation to human rights, rule of law, including this one. In the event that the act has been enacted today, it has been criminalized. It's on a sad note. So what does this give us? This projects a regime that silences dissent. And that has been the power of civil society, or even independent writers, researchers, something of the sort. So let's look at clause 13 that actually brings out the economic sabotage. Yeah, it criminalizes publishing information, which clearly weakens the economy of Uganda. The government doesn't want to be criticized. So much as there are already checks to the freedoms under the Constitution, once this is enacted, even all social media platforms, journalists, whistleblowing, all those are going to be suppressed. And so economically, we are going to look at capital friction as well as discouraging investments, not only from donors, but also investors out there. So looking at part 3, that is the registration of agents of foreigners. Yes. Now part 3 has clauses from 14 to 20, and I'll try to be fast with this. So from clause 14 to 20, it basically brings out the mandatory registration that has been discussed, the intrusive disclosures, the 2-year permits, and the ministerial discretion. So what do we see from this? We realize that this bill actually centralizes all the power in the executive. Where does that leave the balance of powers? You get? we are realizing that the parliament has been bypassed. The judicial checks are no longer considered. You realized, as earlier noted, that in the legal discussion that there is actually no room for appeals once your application is considered not successful. Where does that leave civil society? So we are going to look at a society that transforms freedoms of association into a privilege. You get? That's where it's leading us. It's pushing us actually away from the rule of law. And this is going to create a capacity shock where NGOs are going to downsize, skilled personnel are lost. So talking about a financial shock, this is brought about when there is a delay in funding flows. That's what I mean by a financial shock. So you're going to realize that all these various political, economic impacts are summarized among three shocks. We have a financial shock, we have an operational shock, and we have a capacity shock. When I talk about financial shock, that's what we are all now saddened about, the inflow of funds into the country from your donors, which will raise compliance costs, and donors as well as to donors as well as implementers. That will actually lead to the operational shock. Now, looking at the capacity shock, that brings about the contractual aspect of the institution as well as human capital. Most of us here, almost CSO employees, are based on contracts. You get? Now, we are brought to the fact that we are supposed to actually apply to notify the state or the ministry that 12 months prior that I expect some funding. Where does that leave most of the employees? You're going to find us, we shall call you when the need comes, leaving people there. You get? So that is that. So let's go to the next. So looking at part 4, part 4 brings about the regulating of funding under clauses 21 to 26. Specifically 21 to 22, that's the declaration of funding that has been ably discussed. And this stifles the startups as well as NGOs and diaspora investments. And it also produces the financing shock, that is the capital inflows that have been disrupted. It's something that I've explained. Whereas clauses 23 to 24, that criminalizes disruptive funding or something that you would call foreign funding to the government isn't regulated. By the way, if you actually read this bill, you realize that under these clauses, only funding that is coming to us who have registered as foreign agents is regulated. But that is coming to the government, it's actually welcome without any restrictions or anything of that sort. So such vague provisions lead to risk in targeting legitimate advocacy. Looking at clauses 25 to 26, that, brings about the reporting and returns that are being required by this bill. What is the impact of this? We are literally already doing this. You get? We are always filing. So that's where I still remind you, is our beautiful government actually aware about the laws that are in the country? That's the question that I'll let you answer. Because we realize that these are going to be burdens to even citizens who are receiving remittances. That's what they told you, that you will go abroad and you can't even send money to your own mother. You get? That's where we are standing. And it will also produce an operational shock due to these various compliance bottlenecks. So let's go to part 5. Part 5 is the last clause, has the last clauses, that is the general, where we look at assistance to the minister from all MDAs, basically advised to assist this ministry and this department in implementing this act. So what does this literally lead to? We are looking at an overreach of the executive powers. It's sad to say, but that's where we are leading. Looking at clause 28, that is inspection, that is something my colleagues have discussed. So we realized that actually their surveillance is going to surpass the trust. So I'm not really going to repeat that because it has been ably discussed. Looking at the various regulations, still the minister, at their discretion, they're empowered to make these regulations. That's in the event that they actually think of making them. So that broad discretion risks abuse to civil societies. Because until those regulations are actually made, you will never know. And then same applies to Clause 30 that brings about the amendment of the schedule. So let's first, next slide. Okay, no, that has been ably discussed. But however, this principle of proportionality and rights limitation is actually brought out in a variety of clauses, that is 5, 6, 7, 8, 10, 11, 12, 13, 14 to 20. I do not really want to go into the legal discussion as it has been discussed. So allow us go to the next slide that brings about the internal obligations. As my predecessors clearly discussed, Uganda has commitments. And I'm glad that most of us are civil society members and we actually know the laws that have been ratified by Uganda. Not only ratified, okay, yes, Uganda is a bit wise. There are times that we sign, but we do not ratify. So there are those laws that are not ratified, but signed. Yes. So what does this bring out? We see that Uganda is party to the ICC, PR, and under this, these are the same freedoms that have been discussed, but I'm just bringing out the aspect that they are actually also recognized in the commitments that we signed or we ratified in the various international agreements. Also, the African Charter on Human and People's Rights, that's under Article 9, 10, and 13, as well as the UN Declaration on Human Rights Defenders. So what is the risk of us actually putting to sideline all our international obligations? We are at a risk of sanctions. And this is something that I believe our government is not afraid of, because we've seen the speaker being sanctioned. And it's not a big deal. So they're not really worried about the sanctions, as well as I believe they're not worried about the reputation damage that is yet to come internationally once this bill comes into play. So the next slide is going to talk about an everyday person. What is the impact to an everyday person? Because remember, civil society, we are always on the ground, right? So this is something that you can actually go back home and tell someone who is not aware about this. So to your families, you realize that parents receiving diaspora support risk criminalization, if not registering themselves as agents. Also, the diaspora, these guys have actually been stripped of their citizenship rights as they are now foreigners. We also looked at the various professionals that has been ably discussed, the lawyers, the accountants, even banks, yes, and most especially us, the CSOs. And then looking at the economy, dang. We are looking at diaspora remittances of 2.5 US dollars. That was in 2025, actually last year, as well as the FDI being discouraged. Also faith institutions, yeah, for those who are religious, the churches, the mosques, those lose fundings for their schools, because remember, some fundings is also channeled through churches to support various schools and hospitals in that case. And then when we look at the various youth and women out there who the world has actually channeled a lot of attention to, realize that job creation and empowerment programs are actually going to collapse as civil society is going to be shrinked. So this will lead to a red tape in the country. Let's go to the next. So that is basically summarizing the political economic lens, and we at Justice Access Point termed it as the triple shock that affects the financing, the operational, and the capacity in the country. What is going to be the outcome? Trust me, it's going to be that hollow sovereignty. Yes. And what do we remember about the hollow sovereignty? It will take us to Krasner's concept of organized hypocrisy. Let's go to the next. Yes, so this is basically a figure that tries to help someone understand these different shocks I'm talking about, the financial shock, the capacity shock, the operational shock, and then lastly, what affects, all these are going to literally lead to systemic stress. Now, this stress is going to affect the health and humanitarian crisis, the service delivery breakdown, as well as loss of skilled workforce. That's basically that. And the same is applied. The next is going to be a service delivery matrix, the next slide. This has also been ably discussed by my colleagues. If you look at actually on your tables, there is something that identifies the risks and the risk tier in critical as well as high, but specifically for civil society, we are looking at sectors that are most likely to be affected. We are looking at health sector, the humanitarian and refugee services, governance and legal aid, disaster response. So we also look at those sectors under education support, agriculture, basically all sectors. I don't want to break them down, but it's something very big. And the next slide is going to talk about recommendation, but the most that we can do, and I believe the reason as why we are here, is to actually write a memorandum that is actually required by Friday to ensure that this bill is rejected. I tried to identify what different actors can bring out, but let's maintain to civil society. Let's come together, write memorandums. Everything that you do matters, even if it's just a post on X, even if it's just you talking to your neighbor. Let's fight for ourselves. Yes, and then in conclusion, realize that this bill actually does not protect sovereignty, it rather restricts our freedoms. And yet true sovereignty lies in empowering citizens and not silencing them. As I conclude, I will leave you with a quote from Neil Armstrong. It is one small step for man, but one giant leap for mankind. Please remember that. Thank you very much.
Thank you so much. That was succinct, clear, to the point. Political economy angle and all other angles. Let me give Job some 3 minutes, and then we can wrap this up. So basically, analysis, and then after that we can do a strategy agenda. 3, 5?
Yeah, sure. Okay, thank you so much, James. I will not make a detailed presentation because a number of things that have been presented are similar to the analysis that we've done. I'm pretty sure that for those of you that are on social media and email, you must have been receiving some of the analysis that we have already done. The recommendations, thank you for making those recommendations. I need to mention that the team we are working with has actually moved a step ahead, and a number of actors are already submitting memoranda. I think just a few minutes back, Dr. Miriam Matembe submitted. We have the Muslim community submitting, local traders, media, name it. So that process is ongoing, and I think would like to encourage as many of you as possible to actually go ahead and submit. In fact, this morning, my discussion with Yona and James, we were thinking maybe we should bring all this together and make one submission. But after listening to what has been presented here today, I think we should actually make separate submissions. That doesn't mean that we are not working together. I think what we need is really, if we had about 1,000 memoranda going into that committee, and all of them are saying this bill is bad, it's possible. For the legwork that we've done with some members of parliament, it is actually possible that this thing can be rejected. So don't be so pessimistic, because I think last week, was it last week, Patricia, when we wrote that letter to the MPs, and we made sure that it got into each and every individual member of parliament's pigeonholes, which was just showing them that, you know, as a member of the 11th parliament that is going to pass this bill, you actually are likely to be the first victim of it. Why? because majority of them, they run CBOs, they run NGOs, but even if they don't actually run these CBOs and NGOs, these NGOs and CBOs are doing service delivery in their constituencies, okay? Now, when these NGOs and CBOs close, what does that mean? That the services which have been delivered by NGOs will no longer be there, and the burden to deliver these services will be on the MPs. So the demand on the MP with their small, humongous salary that they are receiving will actually increase. So that is number one. But also number two, 80% of these MPs are exiting, that are going to pass this thing. Where are they going to end up? In civil society, in the private sector. Many of them are going to go in the diaspora and start working there. They will become foreigners, okay, according to this law. Those that will stay here, professionals, lawyers, accountants, they are representing international business clients. What do they have to do? They must register as foreign agents. And on top of registration, get 2-year permits, okay? So they need to know that this law actually has direct consequences for them. The interesting thing is that when you talk to these MPs, even those that cleared this thing in Entebbe, they actually tell you that we didn't know this is the thing that we cleared. When you tell us now, we actually see how dangerous it is. Okay, so they just cleared something. First of all, they confess that they were never given the opportunity to discuss it, which means they didn't even look at it, they just cleared. It's the same thing which was done to them in Parliament when the thing was presented. The bills were supposed to be provided in the pigeonholes. They are not provided. On the Alfresco platform where it is supposed to be availed digitally, it was put there at 10 a.m. By midday, when the bill was being tabled by the minister, it had actually been withdrawn. So these guys cleared something they didn't know. Now, I've listened to ministers and other people that are trying to justify this thing. When you listen to ministers talk about this bill, it is clear they don't know what is even in that bill. Okay? When you listen, I read the article by the Attorney General. Luckily, there's a group which has done a rebuttal. I think it should be out probably today or tomorrow. If you read that article, I don't understand what the Attorney General is saying. The Attorney General is talking about countries which he claims, I think, they are trying to make us believe that they benchmarked on those countries. Australia, Canada, UK, USA. If you read this bill and read the laws of those countries, this is the total opposite of what is entailed in those laws. The countries they benchmarked on, even they themselves are shy to actually talk about them because these are autocracies. Russia, Nicaragua, Georgia, Azerbaijan. The only country actually in Africa which has a law like that is Zimbabwe. And you know what has happened to Zimbabwe? Even Kenya, the example they give, it tried to introduce a law like this in 2013, okay, which was not even really like this. It was just talking about capping on foreign funding, which was overwhelmingly rejected. So it's really interesting that a minister can actually try to use a case of a law which was overwhelmingly rejected to justify why you need a law like this in Uganda. But let me go quickly to the things that I think also probably could have enhanced this analysis that I haven't seen coming out. Clause 14, the conditions for registration as an agent include health status, okay? Yeah, health status. What does that mean? That in order for you to register as a foreign agent, you're going to declare your HIV status to the minister. Isn't that what it means? Because it doesn't even define when we are talking about health. Are we saying if you have Ebola, we can't register you? Are we saying cholera? Are we saying malaria? Are we saying HIV? The other, it is character. Okay? So character, I can look at you and I say, James, you look like you have bad character. Because character is subjective. Someone can think that may have bad manners, when actually another person thinks it's what? It's okay. So for the minister, they will simply look at you and they will say, your character, we can't, you don't qualify. The other worrisome thing is that even the renewal of your permit is actually based on your character. Okay? The other thing is that even the revocation, that actually you can get registered now and get a permit, but after 3 months of implementation, if the minister feels offended by it, they can actually revoke your permit based on your character. When you go and also, of course, the fact that there's no guarantee, even on time, okay, that when you submit your application to the minister to be registered, that within a day or 1 year or whatever, you can actually be registered, or even getting a permit. Now, for those of us that work in the NGO sector, you know how this has been weaponized. As we were talking to to one of the NGOs the other day that was suspended, one of the 10, and these guys are saying that actually we don't even know what permit these people have suspended, because we applied for renewal of our permit more than 2 years ago, and up to now they've never gotten back to us. Okay, so you know actually it's a weapon that they'll use against you. So NGO Bureau denies a permit, the Department of Defense denies a permit, so you stay there like that. The invasion of privacy, okay? We are talking about inspection, and they are talking about any reasonable time. Now, you don't know what reasonable can be to them. Reasonable can be midnight, okay? But also the other reality is that they are not defining what premises are. Many of us are talking about offices, but you know, if you are an agent of a foreigner, your mother, your daughter is a foreigner, she's working in Abu Dhabi, they're calling them kadamas, she's there, you've not registered, okay? Now these guys suspect that you're doing foreign agent activity at your home. And what is the suspicion? You're receiving money from your daughter. They can just enter your home at any reasonable time, reasonable, according to them, okay? Clause 3 to 4, which talk about administration. The bill doesn't describe the composition of this structure. Because I think it should be able to tell us that it should have maybe 10 members. These are the qualifications. We should know. But we don't know. Maybe considering that is in the Department of Peace, they are going to have soldiers that are going to be doing what? Making the composition of this thing. So it's not clear. When you go to clause 30, amendment of the schedule, okay? Currency points, the schedule is the currency points, right? 20,000. And the minister under clause 30 is being given the power to amend this schedule at any time. What does that mean? That tomorrow the minister can actually come and say this schedule is now, a currency point is 40,000. You know what that means, 40,000? Now we've been talking about a fine of 4 billion shillings for an NGO. That would mean that now it is 80 billion shillings. And for an individual it is now 4 billion shillings. We are talking about a cap of 400 million. The minister can come and say that now we've reduced the currency points to 5,000. You know what that means? 5,000, 400 million divided by 5,000. What does that give you? It's, who is the mathematician here? Isn't it like 8 million? 8 million. That would mean that in order for you, if you get more than 8 million shillings within a year, without written permission from a minister, you have committed an offense. Okay? And what is the penalty? 20 years in jail, imprisonment. The final issue I want to speak to is this whole question about the benchmarking, the global comparative. You know, we met with I met with some members of parliament, and when I met them, those that had passed this thing in the caucus in Entebbe, and they said, okay, if we are to look at this bill, okay, and asked you to get one thing you can save in this bill, what would be that one thing? We told them, okay, let's go through this bill together, and then by the end, we can conclude. So we went through from clause 1 to clause 30. You know what the conclusion was? That actually the only thing you can save on this bill is the title. There's no clause that you can save because they are all bad. Okay? Now, like I said earlier, if you look at the global comparative, this law, much as they claim to have benchmarked on UK, USA, Canada, the countries they benchmarked on are Russia, Nicaragua, North Korea, etc. When you go to these countries and you see what has happened ever since they implemented this law, they started implementing these laws. Number one, In one of the countries, over 1,000 civil society organizations deregistered, okay? Just by passing of the law, they seized. Number 2, media, independent media, silenced, okay? Number 3, there was an exodus of people going into exile. And to be honest, between me and you, this is what is going to happen here. People are going to leave, because otherwise, you decide either you're going to just keep quiet and shut up, or they're going to do what? They're going to arrest you. So if you want to remain independent-minded, you may just have to exit the country. They seized assets. Even this law is talking about taking your money. If you receive in excess of 400 million shillings within a year without clearance from the minister, what does that mean? The rest of the money will be taken. Actually, it's not even clear whether it is the rest or not, because the other day I was talking to guys in the Muslim community, and they said, but now for us, there's an NGO here that is taking care of over 10,000 orphans. Every month we are receiving about $1 million to support these orphans, to sink boreholes, to do what? So what then happens to us? So if that $1 million hits the account, already you've committed an offense if you don't have clearance from the minister. What does the law provide? That the government takes that money. Okay? They will take, this is theft. These people are, it is real theft. Okay? But the worrisome thing for me is that when you look at all these laws, okay, there is no law as bad as the one that is being proposed for Uganda. The only law that is proposing stripping you of your citizenship because of moving into a foreign country is this one here. There's no other law. And what does that mean practically? That you know, you can fly to Kenya tomorrow, okay, because the law doesn't even put a timeline, a time frame. As soon as you enter Kenya, you actually become a foreigner. And what does that mean? That if you've left Patricia behind Robert, and I want to send them money maybe to buy for me a plot of land, they must register as foreign agents and get permits every 2 years. So I think the message has to be really consistent from all of us. This bill is bad. It is unnecessary. It deserves to be in the dustbin. It shouldn't have smelled the corridors of Parliament. Be in the bill. Okay? Be in the bill. So my final message to you guys all is that we still have a window of 2 days, tomorrow and Friday, to submit memoranda. Let us mobilize as many people, as many groups as possible, but also from what we've seen, from especially the creatives that had a successful copyright law passed, the strategy that worked for Parliament is really just overwhelm Parliament. Be there. Go there physically, submit memoranda, go there physically, mobilize all your people. In fact, the MPs have told us, you know, you get all your beneficiaries, bring them, children, disabled people, women, people in markets, just bring all of them to Parliament when the public hearings are open. Thank you for listening to me. Yes, the other worrisome thing actually about this bill is that it has no transition clause. Okay, transition clause then, which should be telling you that this bill, I think the NGO Act at some point had one, which was talking about a certain period of time whereby if you're not registered with the bureau, you'd cease to exist. There was that clause which in a way we dealt with. But now this one doesn't have a transition clause. What does that mean? That if this bill is passed on Thursday next week, which is likely, okay, and the president assents to it probably on Friday, it will impact immediately. You all have to register as agents or foreigners. And your relatives that are in the diaspora will automatically become foreigners. By Friday next week, it is possible. It can happen. So that's how dangerous this bill is.
Of course, transition-wise also, if you are in negotiations now for $1 billion shillings, what will happen if it comes when you are at the verge of reception? Of course, my belief is that you're in a negotiation of $1 billion shillings, you know. That's the transition we're talking about here. at soliciting level. Yeah.
So when we write our proposals, we should already be asking for permission.
Yeah. There you are. If it passes next Friday. Yeah. So if there are any hands-on to this, you know, let's hear them. I'm going to ask Hilda. Oh, could you help me pass this around, please? There's a hand there.
Just bring it.
Kindly put it on. Switch it on. Let me begin with Elder.
Good morning to you all.
Yes.
I thank all the teams which have presented and also tried to break down the specific clauses of the bill. I have a few issues I would like
Kindly,
to
your name?
note.
Your name?
Okay. Sorry. My name is Saida Nachilima and I work with Human Rights Awareness and Promotion Forum.
Okay.
My concerns will go to Onyango and Company advocates. A few things which I would want you to note and probably include in the bill. That is clause 6.
No, we want to shoot down the bill. We can't include them there.
Sorry.
In a memorandum,
and include in a memorandum.
Okay.
That is exercising government functions. That is under clause 6 of the bill. Because it talks about the 6th schedule of the Constitution, that everything within the 6th schedule of the Constitution, if the NGOs or any other individual wishes to implement anything related to that, you must seek the cabinet approval. So, and when you try to look down through the things listed there, you will see health policy, education policy, agriculture, and those are most of the things actually we as civil society organizations work on. So basically that means as for us here, if we are to continue providing legal aid services, because it also talks about the functions of the judiciary under that schedule, it means we need to first seek approval of cabinet for us to work on those things, because ideally those are government functions which we should not be engaged in as civil society organizations or as private individuals. So I feel this is a clause which should entirely be deleted from the bill. Then you also look at clause 10 of the bill. That is a prohibition of promotion of foreign policy. First of all, when you look at the bill, it does not define what foreign policy is. All foreign policy is bad, and there are some policies which actually benefit us as Ugandans. So if that clause is also to remain, it will stifle quite a lot of things, including research, because even some of the best practices we have here in Uganda, we copy them from other different countries based on their policies and all that. So if we are to have it, what will be the end of that? Will we ever have any innovations here in Uganda, maybe borrowed from other international models and practices? Then we have clause 23. I also did hear you present on that. That is obtaining funds to engage in disruptive activities. I tried to look at the bill and try to understand if I could get the clear meaning of disruptive activities. I failed. It is really vague. So, with that vagueness, where does it leave us as civil society organizations and NGOs handling different matters, especially organizations involved in issues to do with political and civil rights? I think that is also a clause which should be totally deleted, and any issues underlying that can be handled under the Anti-Terrorism Act.
Okay.
Also, when you look at clause 30,
Yes.
I think we have to look at it in line with Article 79 of the Constitution. That is clause 30 and clause 29. Because issues to do with actually now usurp the powers of the parliament and placing them into the cabinet. So we need to maintain the principle of separation of powers. Who is doing what? Are the roles now getting to the executive, or we are leaving them with parliament as it is in section in Article 79 of the Constitution? I also have some recommendations when it comes to what we need to seek from the government. The specific recommendations. Anyway, I will share those later as maybe someone else.
Okay. Okay. The East. It's good. Yes, the East. So kindly, such that we can get out of here in 30.
My name is Benson Kyochen. I'm not going to give my opinion, but just 2 days ago, we came together as a region, and I'm going to give you a snapshot of what we agreed.
Good.
One is that we say we, as a region, we entirely rejected the bill in the way it is. Say there's nothing to redeem. Even the title you praise here, to us is problematic. And we have 4 reasons why we did that. One, we said that the sovereignty concept is so deep and so broad that it cannot be condensed into one act of parliament. Actually, to us, this concept is about territorial integrity of a nation at all levels. It's about the sanctity of the citizenship and supremacy. It's about self-determination and self-governance and many other things. So, and this one, for us, the Constitution is actually the supreme law on protection, on sovereignty protection. So we don't need another law. We already have a Constitution. It is our document that protects us. When you talk of territorial integrity, it's already covered for. Our boundaries are already defined. The mechanism to protect them is already there under Article 208. We have already established an armed force fully equipped to deal with anybody who will try to jeopardize our territorial integrity, which is a symbol of our sovereignty. Self-governance is already covered. We already have the 3 arms of government covered. So, for us, we think Parliament is attempting to bite more than it is supposed to chew. We are already, so they should change never should they call it sovereignty protection. We are already protected and we have our Constitution. So, to us, that is one. 2 is that Uganda is a republic governed under or using a republican constitution, which establishes that citizens are supreme, the constitution is supreme, everything else is people-centered, and there are many things in our statement which were put. So any bill, any act of parliament that attempts to offend in that spirit, we are not a kingdom, we are not a kingship, we are not a feudal system. So anything which tends to disenfranchise citizen participation, to concentrate in one individual, one minister, to exercise even the power to make a law, to amend and vary a law, is totally unacceptable. And this is what this bill is attempting to do. It wants to drive us back to some authoritarian system somewhere. For us, we don't mind what they are. Our Constitution defines who we are. We are a republic. We are supposed to be governed under democratic principles. This is real principle of state number 2. We are what we have listed all that. So any attempt to take us to authoritarian, which gives ministers of our organs to declassify, to desensitize, to do what is unacceptable. 3.
Ben, you had said that you were going to share with us what you guys, the strategy you used.
Just giving a highlight. The other one is...
A highlight of what? Of what happened? No, what I'm saying, you had a fruitful discussion there. Could you share with us, like, perhaps strategy, which people you reached out to?
Yes, that's what I'm coming to. Three is
Come to it faster.
The intent and the objective, where the intent and objective of the bill is legitimate to us. Every country must protect its sovereignty and so forth. But it is misconstrued. To us in the region, the foreign agent should actually be a foreigner who's attempting or wants to work with us. And is the one who should be regulated. If you go to the US, a foreign agent is actually any non-citizen who is benefiting from American support. And that is the one they have classified, that is the one they are regulating, that's the one they are monitoring, not their citizen. So to us, this is ridiculous. You cannot start calling me a foreign agent. No. Even scientifically, a foreign agent in your body is something from out. That is the basics. So we are saying no, that statement alone is offensive. And of course, the other one is that the bill is obnoxious and is poisonous. We borrowed the words of the president himself, who talked about a poisonous mushroom. And I think this is one of them. And we have listed the very things you talked there, how it offends this, how it does this, how it will affect us, the obnoxious and exorbitant punishments, what and so on. All that to us actually falls under the section of being obnoxious and affecting, and how it will injure our local leaders. For example, in Teso, we have a cultural leader whose mandate spreads up to Kenya. One of his ministers is actually Kenyan. And then the Catholic diocese has sent what they call missionaries to the US. One of them is called Alex Ojachor. He's in the US. He's a citizen there. He's our citizen, but he's a missionary. Now what happens to them? So there are many things which were put under that. Nearly about 17 things under what we call why we think is obnoxious and they must be put aside. So for us even the title is not okay because they should be called protection of maybe controlling and regulating external influence or something like that. Don't talk about sovereignty when it's already supposed to be covered under the Constitution.
Ben, are you submitting that? Was that a written thing? You're submitting it to Parliament or it's up to the region?
It's written.
Is it going to be submitted?
Yeah, it will be submitted.
Okay. So their strategy is submission. I'm interested more in what all of us are doing over and above and included into the section. I don't know whether here you've done something in terms of whether you're reaching out to particular people in your constituency, women, gender, the gender aspects of this. Are there particular attacks you're focusing on? Particular women in parliament, those who are not off the hook, something of that kind, such that we can synchronize. Robert, will come in shortly after.
All right, thank you, colleagues. My name is Mark Chelo from Tusebei sub-region. And we noticed that even the day that the bill was read for the first time in parliament, there were less than 100 members in the house. Some were still in Chankwanzi, others were still traveling. And even the word itself, sovereignty, sounds very big for a local man. We're engaging in survey and making sure that people understand what it means, and even giving the basic examples. I was looking at border communities like even ours, Usebei, where over 90% of the tractors that farmers use are from Kenya to till their lands. And we are trying to break it down, how it does affect them. So one strategy that we are using is we have convened all the radio callers to keep engaging and sharing the message. And then the other one is we've been asking citizens to call the members of parliament, and surprisingly some of them say they have not even read the bill. So the strategy we're using is asking citizens to call the members of parliament to ask them to reject the bill. I thank you.
Thank you so much.
Thank you very much. My name is Lydia Nairoba, a legal officer at Uganda Women's Network. I just want to appreciate the team and also say that as we are analyzing clauses under this bill that I have deadly, we should also take note of clause 23, clause 3, which says that where an offense is committed by a legal entity, any director or executive head is deemed to have committed the offense. So my concern here is not only the liability it is creating for the executive directors, but also the impact it has on leadership. It is likely to suppress people from taking up leadership positions as executive heads. And if where somebody has courage to take up the leadership, then they are most likely to be suppressed from taking decisions or authorizing certain works that are sensitive and that could attract certain penalties under the bill if it's passed into law. So our take is that the bill should be subjected to an independent constitutional review before even it proceeds to the next steps going forward. Thank you so much.
Sorry, you said you come from FOWODE?
Yes.
Is there anything special?
We were planning to write a memo on behalf of the women's movement and have it submitted to Parliament as well. One that we are considering if it could be prudent to have a joint document as civil societies as opposed to having an independent MOU from ONET.
Okay.
But we are working along that line.
Okay. Oh, okay.
I want to thank you. I'm Kauta Abdalatwaha from Peace Bridge Initiative in the Sokasa region. I come from a district called Namaingo. One, I want to mention that, talk about the timing of this bill. The timing was deliberate and it was aimed at disadvantaging the civil society organization. One, it came at a time when the political tenure is coming to an end. Two, when you have just held elections, meaning that the vocal MPs are already deflated because they lost. Three, this bill was talked about in Chankwanzi, where both the NRM members of parliament and the independents were invited. But the last one, which was, I think, a 6-inch nail, was the presidential pledge that MPs were to be given over 100 billion. We don't know why that pledge. It could be one of the reasons to bias them to have this bill passed. As Namaingo, through our NGO forum, we have written to our members of parliament. We are going to visit them tomorrow. It is my humble suggestion that each of us come from a constituency where we are represented by MPs. Let's invite them and discuss with them about this bill.
Okay. You're meeting them tomorrow in Namaingo, right?
Yes.
If you need any help, any legal, anything, please alert us and then we'll back you up. Thank you so much. Someone else?
Thank you very much. My name is Penina Susan Igaga. I'm the Programs Manager at Center for Domestic Violence Prevention, commonly known as CEDOVIL. So I've come to speak strategy, and I would think the way we're going to approach this is going to be multifaceted, and I'm going to look at it threefold and put an emphasis on one. The first being, of course, we already have a lot of engagement that's happening, and the second, we are calling for transparent processes in looking at this bill and eventually passing it into law, which a lot of us are disagreeing on. But I think I would want to hear more about community participation and engagement. And the threefold in this case would be combining public pressure. When we started this conversation, one of the things that was asked to us in the room was how many of us are aware of the bill. There were a few hands that went up. The second was how many of us have skimmed through it, how many of us have thoroughly looked through it. There were a few hands up. Is this something that has been considered country-wise, community-wise, publicly? have all our narratives being put in a language that even the lady in the market, who ideally we are calling on to put pressure on, discussions that affect them, are they able to understand? It's good for us to have these conversations here, and I love the conversations that are going to happen countrywide in the communities in a language that they can understand. We're speaking fancy right now. Maybe right now someone listening to me is thinking she's speaking fancy. What is multifaceted approach? But the point in all this is we need to involve all sectors in all ways. Let's have these conversations. Let's have these conversations at community level. Let's have them at the women level. How is this affecting? How will they understand it? How will they speak up in order to ensure that the threefold of community pressure is eventually used to put pressure on this bill? Thank you.
Thank you. Of course, we are also mindful about the time because it's also a tactic of passing laws. You bombard people very fast when they can't mobilize. I'll hear from you. Yes. Yes, I'm coming to this desk.
Thank you so much. James. My name is John Robert Riacho. I'm the executive director of Africa Economics Network. I'd like to bring in the climate change angle because someone asked a very interesting question. Are all foreign policies very bad policies? We all know that as a global community we're trying to combat climate change. And Uganda has been on the front line to try and see that we, capacitate our communities to be climate resilient and capacity. When we look at our constitution, Article 39, it is quite a very clear one that every Ugandan has a right to a clean and healthy environment. So if you are now struggling, we in the civil society organization, and even say individuals, people, climate activists that are coming out to try and see that we raise, these issues, our people who are vulnerable to the effects of climate change, and promote disaster risk reduction and climate resilience, then it becomes really a very big problem. And also, one thing that we need to be very clear about is that, while government looks at us as if we are really, against them, but we are playing a complementary role. Because the government is very thin on the ground. It is us who are really in the communities trying to see that we, create awareness, what our people need to do to build their capacity. So I think we need to speak to the language that, yes, at the end of the day, while they probably think that we are doing, negative work, but we need to also highlight part of the work, good work that we're actually doing in the communities. And I think on behalf of the climate movement, personally, and the colleagues that we are working with, what we are doing, all of us in the room need to know that Parliament recently tweeted and put out, calling out for voices on X. Those who are on X, please kind of go on the thread and put, the last time I checked, we had about 800 views. If we go there and also bombard their views, maybe some would influence. But also use our spaces, because this is a digital space. We must be able to, make sure this has talkability within, especially the young people, the Gen Zs, because they're the ones who are going to be affected. I think as James, you guided, we need to focus so much on the action points. We have time within today, tomorrow, and Friday to see that this is really very, very serious. And also, as we said, speak to the MPs. The last bit is that true sovereignty is when the citizen is able to exercise their duties. When we look at Article 17 of our Constitution, it talks about every Ugandan having a duty to create a clean and healthy environment. So now if you are saying that for me as a citizen to actually do my role to create a clean and healthy environment, I need to register with the minister, then it becomes very, very, very dangerous. And I think we need to inform citizens the duties and sovereignty is provided for in the Constitution. Because look at Article 50 of the Constitution, and I'm guiding the team that is drafting the memorandum. These articles need to come out. Article 50 says any Ugandan who thinks that the right of a citizen or the right of the environment has been violated, you have the duty to go to court and invoke, probably sue. Some of you have been following, we've been really personal with the South African Court of Justice, combating government on saving the Goma forest. So it is now I will no longer be able to do that because you're saying I'm influencing or opposing. I mean, as a citizen, I should be able to come out and speak out and probably invoke the law, the Constitution, Article 50, and be able to challenge some of these issues. I'm not violating any law, I'm just using my legal power. And therefore I think it is important that if there is any time that we as civil society need to come together, this is the time we all need to come together. Yes, I know it is very, very tricky, but we must have our rights, we must have our citizenship duties, beyond just civil society, but as citizens of this country, to try to see that we call for. What they are calling sovereignty is already provided for in the Constitution, but I see the law is actually taking away the sovereignty because we are taking our duties as citizens no longer exercised. Thank you so much.
Thank you.
Thank you, Robert Tuliachira. This is Robert Mugisa, and after me is Mr. Robert Chilenga. My name is Robert Mugisa. I come from Luwero. I'm a human rights lawyer and defender advocate. I'll use a few parables. Number one is Matthew 12:29 says that no man goes to, let me just what I wrote here. How can anyone enter a strong man's house and carry his possessions unless he first ties up the strong man? January 9th, 2026, the National Coalition, NGO Forum, ACTV, ACFIM, Chapter 4, were what? Suspended. Those were our strong man in quotes. But the beauty is that while the strong man is still tied up, there is another strong man who is rising. Civic Advisory Hub, JAP, and many who have convened us here. Thank you very much. So it means that there is somebody who knows the power that we have, and they are trying to silence that power. But the more they silence that power, it means that others are rising. And for me, that is a positive trend. Number two, if I were driving to Fort Portal and I found the sign diversion ahead, I would understand because the road is bad and probably they are working on it. But if I'm driving to the airport and I find diversion ahead, then I would wonder what diversion, because I think the road is very clear for me to travel fast. So that's what is happening, that while we think the nation should be driving forward without any interruptions, then we are being diverted where there is no need for a diversion. And so these laws, sovereignty, our country is sovereign, yes, and the role of the state is to make sure that this sovereignty is protected, yes. But what are you proposing in terms of protecting this sovereignty? You're stifling certain people in the name of protecting sovereignty, which we are rejecting, because we are saying there is no need for that at the moment. We are okay, let us work well. Someone talked about the annual budgets. When we work as NGOs, yes, when you look at the funding proposals and all this, our budgets are far bigger than 400 million. So how shall we operate? How shall we continue to seek permission to adjust beyond the threshold of 400 million, which is about 106,000 US dollars? We need to work beyond that freely and openly. Robert is talking about Article 50, rejoin that with Article 38 that we always talk about. As civil society organizations, we are supposed to be very free to operate and do our work. Otherwise, our communities which we advocate for, the rights that we advocate for, are going down the drain, and the effect is that, one, diversion, two, image of our country is being tarnished, because while we are advocating for rights, there is somebody out there who is saying, no, Robert, I cannot give you beyond this level because your state is saying we cannot give you beyond this amount of money. So you have a very good proposal, but I can only give you this amount. And therefore, the effect or the end result is stress and death of our communities.
Thank you very much, colleagues. I'm also called Robert Chilenga. And as James told you, we are among those who were put on forced leave. I just want to emphasize one thing. Please don't underestimate your capacity to influence just as one individual. You, one alone, can do something that we thought could happen. So please don't underestimate it. I called the rector of one of the major seminaries in this country, because I knew that he had a direct link to the Archbishop and the Episcopal Conference, which is the highest decision-making body in the Catholic Church, said, are you aware of the sovereignty bill that is coming up? He really showed me that he had nothing. So I pumped him with all the information. He said, are you sending me genuine information? It is. Please pick it up. So the point I'm trying to emphasize, please, at your own level where you operate from, especially you who are dealing with, normally, civil society, people who deal with socio-economic rights tend to think that they are never under threat, unlike those who deal with civil liberties. You who are complementing government, the ones who are valued, I'm talking about CISBAG, I'm talking about SEHAD, you who do service provision in the health sector, education sector, you have a key role to play in this matter. Because you deal directly with the beneficiaries. When we talk to the MPs in the caucus, NRM, which has a majority, they tell you, please, Bob, at least send us pressure, so that when we're in the caucus, we tell, but we are getting a lot of pressure from our constituency. So please do it. They want, once he will say that, Bob, I'll be able to stand on the floor and say, look, the pressure I'm receiving from my constituency is too much. From the NGOs, they want this bill totally reversed. The group of elites who support this bill are beneficiaries of a patronage system, so blame them sparingly. There are those who want to be appointed acting judges. There are those who are looking at many things, and they are our colleagues. Blame them sparingly. They also want to be part of a system. But we should be able to tell them that at the end of the day, this thing is going to bite them. All these MPs who are beneficiaries of the patronage system, their children don't study from here. They are in Canada. You go to Canada and they will tell you the number of Ugandans in a certain province there who have bought property there. But this thing will catch up with them, because eventually that money they will want to bring it here. And you know that our system, you can never trust it. Tomorrow you are part of the system, you are high up there, you are Inspector General of Police, you are Army Commander. The system drops you down all of a sudden. This is not a government bill, it's a state bill. And you should be able to differentiate between state and government. Unless you differentiate between state and government. When you talk to our colleagues whom we went to school with in Ministry of Finance, I've just sent a text to the director in the Bank of Uganda. I asked her, could you kindly tell me what kind of information or document would I publish that would weaken the economy? She asked me, Bob, why would you want to weaken the economy? That was an indicator that she has nothing. Then when I told her about the sovereignty bill, she said, Bob, that bill, then she just stopped there. So it's an indicator. Not all the technocrats, it's only those who are benefiting from a patronage system that want, but they also don't know that it will affect them. Thank you very much.
Thank you so much. I'm going to begin now descending this plane. Shall hear from Ben, and then this 1, 2, 3. Yes. 1, 2, 3. And then please, if you have a comment that you think is expansive, you scan, then you type it, and then these comrades will receive it, and then we can discuss what after now are we going to do.
Thank you very much, James. I'll make it quite short and quick. My name is Philip Eric Bakarikwira, coming from Jinja. I'm into the natural resources sector. When we first heard about the bill, what tickled us was the department in charge, that's security and peace. And what we do is a livelihood issue. Our conversation is purely on livelihoods, people who are in the natural resources sector. And we convened within Jinja, and we said, what do we do? How would we become relevant? And normally our approach has been more with the media advocacy. Without having any legal interpretations, we thought we would first tickle the conversation to the population for a buy-in. And many of us, we are more of ardent radio panelists. But what we understood, even the moderators on the radio stations didn't have any knowledge about this. But now another issue was the time of submission, when they intend to convene. So what tickled us was why the rush. And at the end of the day, with this legal interpretation and the convening of CAR and other partners, as we craft what we intend to take there, we had this recommendation. Of course, we are continuing to do the media advocacy through engaging with many people in that kind of thing. And we said one thing: if it's peace and security, it becomes more of a national issue. It does not segregate. And if there is anything that they would wish this bill to be passed into law, it comes back to the population. And our recommendation, we are trying to craft recommendations, and we said, and you'll be guided by the legal experts. It's a security issue, it's a national issue. If there is anything they would desire, we recommend they cause a referendum. They give this time to go and deflate this bill to the population. Then they allow the population to decide whether the bill is pro-people or it's not people. So in the recommendations, as we craft, that in case they insist that they want it, because we know they want it for their selfish reasons, but let them allow the population to have a contribution. And we cause a referendum, a national referendum to this bill, so that it ceases to be at that level, but they allow the Ugandan citizens to pass it. Because now when we cause a national referendum, we shall have enough time, other than rushing us, and we go. Now that we have the interpretation, we shall continue using our strategies, media advocacy, causing community barazas, and we dissect in the local language to the population, clause by clause, sector by sector, with a red pen, so that the population tends to understand, because this is a livelihood issue. I submit.
Thank you very much. I'm Robert Kakuru from Chigezi. Last Saturday, after accessing this bill, for us we are very lucky that this bill was shared to some of us by some of our members of parliament, for us to start, analyzing it. Then later on we got it from also our sector leaders. So we convened last Friday. We convened a group of land friends, the lawyers, and to interpret this for us. We were in a certain hotel. Lucky enough, one who gave us the hotel, it was still free of charge and tea for us to analyze it. Lawyers helped us through. Then the following day, we hosted a dialogue of all stakeholders, and the stakeholders had different resolutions. One of them was, we need to localize this conversation. And how did they agree to localize it? Church leaders who were there, to allow every member who was present, who understood the bill, to be given a platform in the church and speak about it. And some of the members of parliament from our region committed to that. Actually, 3 of them have already done it. Honorable Wilfred Nwagaba addressed a congregation where all Catholic bishops from Western Uganda had gathered at Rushorozi in Kabale. And he told them that, bishops, there is nothing good for us in this bill. Even the heading is not good. And when he split it to them, it was a conversation all over, and it is a discussion. The second way of localizing this, they agreed, we need to write a message, like something like a sticker, small sticker. Give it to every border guy from Kigezi, writing a message saying, MOP reject this bill. And every person, so meet these informal groups, talk to them about this message so that they have what to explain. And that one has already started. Then the other one is radio talk shows, and then any other social media platform. As we say, we have all local radios in Kigezi have invited us. I shared some of invitations to appear on Saturday and talk about this. So we have already divided ourselves. Some people to go to each district in that region. So Saturday it will be a party of discussions around this bill. So I want to tell you that we don't need to give up. But the group of lawyers I have here yesterday, all lawyers who met us to explain this the way our colleagues have done, they were slapped a bill of taxes by URA. There's a Muhanji company, Muhanji and the company advocates, that stuff. Yesterday they were minded, you are demanded this. Another one, you are demanded this. Another one, you are. So as we do this, we have lots of threats. I think maybe our colleagues from here, you will receive yours. Thank you very much.
Yeah, thank you very much. FOWODE is my name. Yeah, thank you very much. This is FOWODE from IST, and I'm happy that we are having this conversation today. And I remember you've raised your voice that where are the women we are talking about, if you look at this bill. And I'm happy to inform you that I have my market women with me here. We have women from Nakawa, we have women from Karerwe and Kasubi markets. And working with these women, and I'm happy that FOWODE and the advisory hub that we're having this conversation. Because after here, we wanted these women, and we always emphasize that they take back this information to other market women. Because if you looked at the previous campaigns, we had the aspirants going to these markets to seek for votes. And these women now, they have access. We've been able to create platforms for them to have these discussions and dialogues with them. So now we have a point of pressure where they're going to go back, create a space so that they can talk to these members of parliament. Like, you came for the votes, but now you have to defend us, isn't it? Yeah, and lastly, I want to add my voice to Mr. Robert in climate justice, that besides us being complimented to government, that as the world and as Uganda, we are behind when it comes to climate financing. The amount of money we need is around $7.3 trillion per year up to 2030. So if you're bringing such a bill which is limiting funding from other nations so that we continue the fight to climate justice, I think we are lagging behind. And for your information, when it comes to issues of just environmental protection, it doesn't have borders. You can have the bill here, but if the pollution is ongoing in Uganda, Kenya, Tanzania, like the air pollution doesn't have a border, it will cross to Uganda. Are we together? So I think this is a good platform that will raise our voice so that we kick away this bill. Yeah, thank you very much.
Thank you. You want to talk? Oh, sorry. You'll have to move away. Direct the speaker. Is okay? It was me who was under.
I just wanted to ask Abdul about the environmentalists to find out if they are doing any organizing to submit a memorandum, because we talked to someone in the climate change environmental cluster, and they were saying, for us, that's why we decided to go and start building movements. This thing you're not going to succeed in your advocacy. So I'm just curious to know whether there is any organizing by the environmental climate change groups to actually submit a memorandum.
Yeah, so Robert, you've heard. So we expect something from you people. The implications on climate justice, the climate moves going on around the world. So let's close this chapter in perhaps 3-4 ways. What is very clear though, obviously, those of you who were part of the POMA thing, there is a moment where the state said to us, the letter rounder, that I can't go back to cabinet and I say that you rejected the entire bill. So he said, let's sit section by section. What do I give you? What do you give me? Okay? That's actually how section 44 got to be retained, because he said, I'm not going to give you 44. I need 44. Those who are on suspension were suspended under 44. So perhaps there is a, and colleagues will help us here, and even the conversations going on there. What if a moment like that comes and says, we're not taking it back, but let's debate what you want in? Because we may also anticipate that question coming, or that phase of resistance from them, that okay, we have heard you. What do we remove? Why do we keep? Okay, I'm just sounding this based on the best practices we had in POMA, where we all went thinking the guy is going to say, okay, I'm taking it back. And somehow, if we were not stable in terms of analysis, we would have had no rebuttal. So we should also be alive to the possibility of cornering that, okay, we are retaining, but can we now begin phrasing these things, and see? That's another thing. Because the ideal, I think, which we all take here is a rejection, total rejection, right? Yes. That seems to be the consensus. Total rejection. Take back, don't bring back. Okay? And then there was another thing of, okay, you're saying rejection at what level? Is it take back and return, improved, or take back totally? All these dynamics will come into play at negotiation level. But I think from consensus here, it seems to be that total what? Is it part the same? Patricia, you're saying something?
I'm sorry, I've been in and out, and I'm not sure whether the already existing legal framework was discussed. Yeah. Because if you look at the bill and the issues it is saying it's trying to cure, these issues are actually already in existing laws. The Political Parties Act, the Penal Code, the NGO Act, the Anti-Money Laundering Act, the Anti-Terrorism Act, the Financial Intelligence Authority. The laws are already existing. So I think the push would be, if the laws are weak, strengthen them. Yeah? Instead of bringing another law that brings more complications like we have seen and so on. So I think that would be the pushback. Because honestly, right from the definitions, the bill is bad. So if you ask us, what can we save? So are you going to say, okay, redefine who an agent is? That practically takes the whole bill down. Yeah, so, yeah.
That serves the day. But now that means, what you say, Patricia, is that there must also be a deliberate agenda from the clauses to say this clause is catered for by this section. Clause catered for by this section. Clause catered for by this section. Deduction, no need. Like, that the thing we have here of the risk analysis? That's wonderful.
Yeah, so we can just share.
Maybe just not necessarily share, but create different levels of information. That part, then the risk part, and all these other things. We have colleagues who are online. Allow me speak to them. Just give them an opportunity to be heard. This is Comrade Chilunda Ali Aaron. On the other hand, Chilunda, I hope you're listening to me. Everyone here is listening to what I'm going to read that you've written. On the other hand, for the purposes of national interest, it will help our country to curb down foreign interference in our internal politics. We have seen the so-called superpower bringing oil democracy. Now that Uganda has oil, these are people's views. If we must register as foreign agents, what's our messaging to communities? We don't want the label to erode trust with VHTS. This is the health, and mothers we serve. How do we protect district-owned donor-funded models from being mislabeled as foreign interference? Is there a plan for a joint legal support if CSOs face selective enforcement? Once the bill passes, this is Comrade Judith Matura. And then lastly, Godfrey Muhwezi. The bill is totally anti-development, selfish, dehumanizing, shameful, and the Parliament of Uganda must not give it life to exist as a law. let me repeat this, the bill is totally undevelopment, selfish, dehumanizing, shameful, and the Parliament of Uganda must not give it life to exist as law. Yes, then the others were thanks and followings. And then lastly from Emily, as we continue the discussion, one thought continues to stand out. Our first lens is not just a policy, but the people listening to the perspectives shared. It is clear that it's more than a regulatory conversation. It is a workforce conversation across our sector. Many employees are paid through international systems, funded by donor-supported programs, delivering work that is globally financed but locally experienced. This is some good literature. Delivering work that is globally financed but locally experienced. Behind every policy shift, real questions are already emerging. What does this mean for job security? How will organizations adapt? How are we prepared to navigate this uncertainty responsibly? The moment calls for thoughtful, proactive leadership. How we respond now will shape organizational stability, trust in leadership. As this conversation continues, HR must remain at the center. That is human rights, not just interpreting change, but humanizing it. I would like to propose the following for the memorandum. Parliament should delete the words foreign agents from the draft bill and clearly define what is made by foreign influence. I think this one is looking at the moment later on, should it come. Attention, recording, I agree to the idea of submitting several memorandums as compared to one joint one. Maybe perhaps from this meeting we can have a joint one, but members should be encouraged to submit different ones. This is what has been. To us exert pressure. I respectfully support the need to protect Uganda's sovereignty and prevent unlawful foreign interference. However, this bill in its current form appears too broad. The bill has already been read for the first time and referred to the Committee for Scrutiny. I would therefore recommend a balanced approach in my submission, support the principle, but call for substantive amendments. I think it's talking about a situation should we be pushed to that. Then Helen Namialo, does NSCS pattern have an idea of how we can force the Parliamentary Committee to look into all the submissions and acknowledge it by stamped copy or an email? Precedence shows that Parliament ignores recommendations and copies of bills come out as was nothing without any change. Fred Sinkindi, sadly the idea of demanding our rights has been eroded. We are now discussing negotiating our rights. There is quite a lot here. We are going to take it up and then incorporate it in our discourses later on. Thank you for the colleagues who are online. I see some of them are actually not in Uganda. The thing doesn't show that they're not in Uganda, but some of them we know they're not in Uganda, but they're keeping tabs. We want to thank you, all of you foreign agents to be, I think next week. Thank you for participating. If things don't go as planned. Yes.
I just communicated to a clerk to Parliament, one of the clerks in Parliament. He said it's not enough to send the memoranda on the other email address of clerk at Parliament. He says follow up that memoranda with, there is a telephone number on the notice. Please call them and say I sent an email with my memoranda. I want to know when I'm scheduled to appear before the committee. The next issue, they are going to open up all the memorandums and they are going to assign you, looking at what you've submitted, if it matches with what he or she has, they are going to put you together and you'll all appear, yes, you'll all appear as one group. Because they told me that they are not going to bring the religious leaders and be with civil society in the same meeting. They don't do that. The religious leaders want to be treated separately. So please, the point is this, that's not enough to send the memorandum. Please follow up with a call and say, look, I'm so and so. I sent a memorandum on this and this day. I want to know when I'm scheduled to appear before the committee. Thank you very much.
Thank you so much for that information. Yes.
We have also heard that the committee has given Friday for CSOs, activists on Friday. Friday is the day that has been given for our sector.
This one or next?
But it's this one. This Friday, because if you had, the deadline for submission of memoranda is Friday. What we have also heard is that when the memoranda are received, the committee is going to retreat next week. And on Thursday, the full House will listen to what has come out of the committee. So those are the timelines we are working with. Yeah.
Of course, some of your organizations have a religious background. I mean, they are all weapons like prayer, fasting, and all of that. We welcome all of them. Otherwise, on my own behalf, thank you so much. I want to thank JAP. I want to thank the CAR. I want to thank FOWODE. I want to thank our comrades here who have given us an opportunity, as well as the very brilliant, precise piece from JAP. I know for a fact this is going to be put together, but let Yona come and complete this, and then we can roll out.
Is it an afternoon or is it still a morning? Good afternoon, potential foreign agents. I didn't wake you up. Colleagues, on behalf of the Civic Advisory Hub, Justice Access Point, and FOWODE, we are more than grateful for you taking time off your busy schedule to come and voice out your concerns as a member of the civil society sector in Uganda on this very dangerous bill. By consensus, I think every member in here and out here says no to the bill. Are there members who say yes to the bill? No. No has taken it. The noes have it. So what are we going to do next step? Anyone who has a stick to fight in the name of concern, in the name of the paper they can write, please take them as many in thousands, because pressure is demonstrated by numbers. 2, the collaborating entities here, with the permission again, we are going to collect the views here and from the members online, and for those ones who have already knocked yes, that their organization should be included in the joint analysis, then we take it to the parliament. Actually, we are not going to wait for Friday. You never know, there might be something in Kampala on Friday. So the legal team, you are not going to sleep, integrate all the opinions, but the big issue is no to the bill. We are submitting the bill to the following entities. Like Helen has actually clarified that sometimes big opinions are given and they are ignored. We want to submit this bill to the clerk to parliament. We want to submit this bill to the main regulator NGO Bureau. We must have a stamp. We want to submit it to the Ministry of Internal Affairs. We want to submit it to the Ministry of Justice. We want all the necessary bodies, entities that are going to be, in one way or the other, offering oversight and supervision to this particular bill should receive the bill. And key to it, take it also to the Uganda Joint Christian Council, because they have a voice. We are building collective power, and we should be together as a united front to fight this bill. Colleagues, with those few remarks, I should say enjoy your lunch as you are pushing back the bill. Asanteni sana.
Hilda, should we take a group photo for history? I mean, people who fought the battle and lost or won, regardless. Where do you want it? Outside. So we pass here or we just come directly? Oh, okay. So we can go via there and just take a simple photo. La Fatale, La Behind. Ladies and gentlemen, I'm requesting that we just go out and take a group photo for memory purposes. Yeah, outside. People who are pretending to be on the phones, I'm saying that we go and take a quick photograph there, from outside there.
Okay.
Hey, people who are pretending to transact phone. We just pass there, like go out and then we take it. Our photographers are there.
Yes,
wherever.
They should send my radio team the logo.
You people, I'm on you. We are taking a photograph there outside.
I think let's ignore the group photo.
Should we do?
Because people are
really want to be agents of foreign interference.
No, we already have all these photos.
Sorry.
I think the top would be us. Yes, sir.
James.
No. You didn't know that closed. You didn't know that closed.
No, I didn't know. I didn't know.
It's just that people, I think, now when the closure happened, Chapter 4 really quickly Twitter. Now for me, okay, look, actually tested because we are just giving me a permit on Monday. Then the letter of suspension came on Friday, signed by the same person. But then he called me and said, I'm just going to come back here and in a position where you are safe. So he gave me almost 3 years. So when now the administrator reaches and then people are online, then he texted me and said, let's go public. Because it seems beyond me. So I convinced the board said that because what we wanted, my members wanted to sue me, they even dropped him. You know, young and they wanted to take on that quickly, you know, it's different, judicial review, what, why not. But when